This is a reading of the legal brief filed in Georgia by Sydney Powell. I finally found it. Hopefully this video is not as long as I expect it to be. However, I think it's going to be pretty long. I'm going to let it play on my TTS. It might wind up being a couple parts. Just a warning. If you wind up watching it and it cuts off in the middle of it, that is why. Just look for the next video. Here we go.
In the United States DISTRICCT Court, Northern DISTRCOICT of Georgia, Atlanta Division. CORECO Jakin Pearson. Vicky Townsend Consiglio. Gloria K. Godwin, James. Kenneth Carroll, Carolyn Hall K. Snow. Fisher, Kathleen Alston Latham. And Brian J. Van Gundy. Plaintiffs. V. Brian Kemp, in his official capacity as Governor of Georgia, Brad Raffensperger, in his official capacity as Secretary of State and Chair of the Georgia State Election Board. David J. Worley, in his official capacity as a member of the Georgia State Election Board. Rebecca N. Sullivan, in her official capacity as a member of the Georgia State Election Board. Matthew Mashburn, in his official capacity as a member of the Georgia State Election Board. And Ann La, in her official capacity as a member of the Georgia State Election Board. Defendants. Complaint for declaratory, emergency, and permanent injunctive relief. 1. Nature of the action. This civil action brings to light a massive election fraud, multiple violations of Georgia laws, including OCGA Sections the 30th of February 21D, the 31st of February 21, 21 to 2-33.1 and Section the 21st of February 522, and multiple constitutional violations, as shown by fact witnesses to specific incidents, multiple expert witnesses and the sheer mathematical impossibilities found in the Georgia 2020 general election. 1. As a civil action, the plaintiff's burden of proof is a preponderance of the evidence to show, as the Georgia Supreme Court has made clear, that I was not incumbent upon plaintiff to show how the voters would have voted if their absentee ballots had been regular. Plaintiff only had to show that there were enough irregular ballots to place in doubt the result. Meade v. Sheffield, 278 GA. 268, 272, 601 SE2 D99, 102 2004 citing Howell v. Fears, 275 GA. 627, 571 SE2 D392 2002. 1. The same pattern of election fraud and voter fraud writ large occurred in all the swing states with only minor variations. See expert reports regarding Michigan, Pennsylvania, Arizona and Wisconsin. See William M. Briggs Deckel, attached here to his X. 1. Report with attachment. Indeed, we believe that in Arizona at least 35,000 votes were illegally added to Mr. Biden's vote count. 2. The scheme and artifice to defraud was for the purpose of illegally and fraudulently manipulating the vote count to make certain the election of Joe Biden as President of the United States. 3. The fraud was executed by many means, too, but the most fundamentally troubling, insidious, and egregious is the systemic adaptation of old-fashioned ballot stuffing. It has now been amplified and rendered virtually invisible by computer software created and run by domestic and foreign actors for that very purpose. Mathematical and statistical anomalies rising to the level of impossibilities, as shown by affidavits of multiple witnesses, documentation, and expert testimony evince this scheme across the state of Georgia. Especially egregious conduct arose in Forsyth, Paulding, Cherokee, Hall, and Barrow County. This scheme and artifice to defraud affected tens of thousands of votes in Georgia alone and rigged the election in Georgia for Joe Biden. 250 U.S.C. Section 20701 requires retention and preservation of records and papers by officers of elections, deposit with custodian, penalty for violation, but as will be shown wide pattern of misconduct with ballots show preservation of election records have not been kept, and Dominion logs are only voluntary, with no system-wide preservation system. 4. The massive fraud begins with the election software and hardware from Dominion Voting Systems Corporation. Dominion, only recently purchased and rushed into use by defendants Governor Brian Kemp, Secretary of State Brad Raffensperger, and the Georgia Board of Elections. Sequoia voting machines were used in 16 states and the District of Columbia in 2006. Smartmatic, which has revenue of about $100 million, focuses on Venezuela and other markets outside the U.S. 3. After selling Sequoia, Smartmatic's chief executive, Anthony Mujica. Mr. Mujica said he hoped Smartmatic would work with Sequoia on projects in the U.S., though Smartmatic wouldn't take an equity stake. ID. 5. Smartmatic and Dominion were founded by foreign oligarchs and dictators to ensure computerized ballot stuffing and vote manipulation to whatever level was needed to make certain Venezuelan dictator Hugo Chavez never lost another election. See redacted whistleblower affiant, attached as X. 2. Notably, Chavez won every election thereafter. 3CWSJ.com, Smartmatic to sell U.S. unit, end probe into Venezuelan links, by Bob Davis, December 22, 2006, https://www.wsj.com/articles SB116674617078557263. 4. As set forth in the accompanying whistleblower affidavit, the Smartmatic software was designed to manipulate Venezuelan elections in favor of dictator Hugo Chavez. Smartmatic's electoral technology was called Sistema de Gestión Electoral, the electoral management system. Smartmatic was a pioneer in this area of computing systems. Their system provided for transmission of voting data over the internet to a computerized central tabulating center. The voting machines themselves had a digital display, fingerprint recognition feature to identify the voter, and printed out the voter's ballot. The voter's thumbprint was linked to a computerized record of that voter's identity. Smartmatic created and operated the entire system. 7. A core requirement of the Smartmatic software design was the software's ability to hide its manipulation of votes from any audit. As the whistleblower explains, Chavez was most insistent that Smartmatic design the system in a way that the system could change the vote of each voter without being detected. He wanted the software itself to function in such a manner that if the voter were to place their thumbprint or fingerprint on a scanner, then the thumbprint would be tied to a record of the voter's name and identity as having voted, but that voter would not be tracked to the changed vote. He made it clear that the system would have to be set up to not leave any evidence of the changed vote for a specific voter and that there would be no evidence to show and nothing to contradict that the name or the fingerprint or thumbprint was going with a changed vote. Smartmatic agreed to create such a system and produced the software and hardware that 5. Accomplished that result for President Chavez. CID. See also X. 3. F. Cardozo, attached here 2. 8. The design and features of the Dominion software do not permit a simple audit to reveal its misallocation, redistribution, or deletion of votes. First, the system's central accumulator does not include a protected real-time audit log that maintains the date and timestamps of all significant election events. Key components of the system utilize unprotected logs. Essentially, this allows an unauthorized user the opportunity to arbitrarily add, modify, or remove log entries, causing the machine to log election events that do not reflect actual voting tabulations, or more specifically, do not reflect the actual votes of or the will of the people. See Hersty August 2019 declaration, attached here 2 as X. 4, at pars, 45 to 48, and attached here 2 as X. 4b, October 2019 declaration in document 959 to 4, at p. 18, par, 28. 9. Indeed, under the professional standards within the industry in auditing and forensic analysis, when a log is unprotected, and can be altered, it can no longer serve the purpose of an audit log. There is incontrovertible physical evidence that the standards of physical security of the voting machines and the software were breached, and machines were connected to 6. The Internet in violation of professional standards and state and federal laws. CID. 10. Moreover, lies and conduct of Fulton County election workers about a delay in voting at State Farm Arena and the reasons for it evince the fraud. 11. Specifically, video from the State Farm Arena in Fulton County shows that on November 3rd, after the polls closed, election workers falsely claimed a water leak required the facility to close. All poll workers and challengers were evacuated for several hours at about 10 p.m. However, several election workers remained unsupervised and unchallenged working at the computers for the voting tabulation machines until after 1 a.m. 12. Defendants Kemp and Raffensperger rushed through the purchase of Dominion voting machines and software in 2019 for the 2020 presidential election. 4. A certificate from the Secretary of State was awarded to Dominion for Georgia Governor Inc.'s law to replace voting machines. The Atlanta Journal-Constitution, AJC News Now, credit, copyright 2019 The Associated Press, June 2019. https://www.ajc.com/blog politics Georgia Governor Inc.'s law replace voting machines XNX's 0 Byquavix 27 KJDQO. 7. Voting systems but is undated. See attached here 2x. 5. Copy certification for Dominion voting systems from Secretary of State. Similarly, a test report is signed by Michael Walker as project manager but is also undated. CX. 6. Test report for Dominion voting systems, Democracy Suite 5-4A. 13. Defendants Kemp and Raffensperger disregarded all the concerns that caused Dominion software to be rejected by the Texas Board of Elections in 2018, namely that it was vulnerable to undetected and non-auditable manipulation. An industry expert, Dr. Andrew Apple, Princeton professor of computer science and election security expert, has recently observed, with reference to Dominion voting machines, I figured out how to make a slightly different computer program that just before the polls were closed, it switches some votes around from one candidate to another. I wrote that computer program into a memory chip, and now to hack a voting machine you just need 7 minutes alone with it and a screwdriver. Attached here 2x. 7. Study, Ballot Marking Devices BMDs Cannot Assure the Will of the Voters by Andrew W. Apple Princeton University, Richard A. DeMillo, Georgia Tech Philip B. Stark, for the Univ. of California, Berkeley, December 27, 2019. 5. 5 full unredacted copies of all exhibits have been filed under seal with the court, and plaintiffs have simultaneously moved for a protective order. 8. 14. As explained and demonstrated in the accompanying redacted declaration of a former electronic intelligence analyst under 305th Military Intelligence with experience gathering SAM missile system electronic intelligence, the Dominion software was accessed by agents acting on behalf of China and Iran in order to monitor and manipulate elections, including the most recent U.S. general election in 2020. This declaration further includes a copy of the patent records for Dominion systems, in which Eric Coomer is listed as the first of the inventors of Dominion voting systems. See attached here too as X. 8. Copy of redacted witness affidavit, 17 pages, November 23, 2020. 15. Expert Naveed Keshavarez Nia explains that U.S. intelligence services had developed tools to infiltrate foreign voting systems, including Dominion. He states that Dominion software is vulnerable to data manipulation by unauthorized means and permitted election data to be altered in all battleground states. He concludes that hundreds of thousands of votes that were cast for President Trump in the 2020 general election were transferred to former Vice President Biden. X. 26. 9. 16. Additionally, Incontrovertible Evidence Board of Elections records demonstrates that at least 96,600 absentee ballots were requested and counted but were never recorded as being returned to county election boards by the voter. Thus, at a minimum, 96,600 votes must be disregarded. See attached here 2, X. 9, R. Ramsland F. 17. The Dominion system used in Georgia erodes and undermines the reconciliation of the number of voters and the number of ballots cast, such that these figures are permitted to be unreconciled, opening the door to ballot stuffing and fraud. The collapse of reconciliation was seen in Georgia's primary and runoff elections this year, and in the November election, where it was discovered during the hand audit that 3,300 votes were found on memory sticks that were not uploaded on election night, plus in Floyd County, another 2,600 absentee ballots had not been scanned. These found votes reduced Biden's lead over Donald Trump 6. Recount find thousands of Georgia votes. Atlanta Journal-Constitution by Mark Nias and David Wickert, November 19, 20. https://www.ajc.com/politics recount finds thousands of Georgia votes missing from initial counts ERDRNXPH3REQTM4SOINPSEP72M. 10. 18. Georgia's election officials and poll workers exacerbated and helped, whether knowingly or unknowingly, the Dominion system carry out massive voter manipulation by refusing to observe statutory safeguards for absentee ballots. Election officials failed to verify signatures and check security envelopes. They barred challengers from observing the count, which also facilitated the fraud. 19. Expert analysis of the actual votes set forth below demonstrates that at least 96,600 votes were illegally counted during the Georgia 2020 general election. All of the evidence and allegation herein is more than sufficient to place the result of the election in doubt. More evidence arrives by the day and discovery should be ordered immediately. 20. Georgia law, OCGA the 21st of May 552 provides for a contest of an election where 1. Misconduct, fraud, or irregularity by any primary or election official or officials sufficient to change or place in doubt the result. 3. When illegal votes have been received or legal votes rejected at the polls sufficient to change or place in doubt the result. 4. For any error in counting the votes or declaring the result of the primary or election, if such error would change the result. Or 5. For any other cause which shows that another was the person legally nominated, elected, or eligible to compete in a runoff primary or election. 11. 21. As further set forth below, all of the above grounds have been satisfied and compel this court to set aside the 2020 general election results which fraudulently concluded that Mr. Biden defeated President Trump by 12,670 votes. 22. Separately, and independently, there are sufficient constitutional grounds to set aside the election results due to the defendant's failure to observe statutory requirements for the processing and counting of absentee ballots which led to the tabulation of more than 50,000 illegal ballots. The parties. 23. Plaintiff Corrico Jakin, C.J. Pearson, is a registered voter who resides in Augusta, Georgia. He is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. He has standing to bring this action under Carson v. Simon, 2020 U.S. App Lexus 34184 8 CIR. October 29, 2020. He brings this action to set aside and decertify the election results for the office of President of the United States that was certified by the Georgia Secretary of State on November 20, 2020. The certified results showed a plurality of 12,670 votes in favor of former Vice President Joe Biden over President Trump. 12. 24. Plaintiff Vicki Townsend Consiglio is a registered voter who resides in Henry County, Georgia. She is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. 25. Plaintiff Gloria K. Godwin is a registered voter who resides in Pierce County, Georgia. She is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. 26. Plaintiff James Kenneth Carroll is a registered voter who resides in Dodge County, Georgia. He is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. 27. Plaintiff Carolyn Hall Fisher is a registered voter who resides in Forsyth County, Georgia. She is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. 28. Plaintiff Kathleen Alston Latham is a registered voter who resides in Coffee County, Georgia. She is a nominee of the Republican Party to be a presidential elector on behalf of the state of Georgia. 13. 29. Plaintiff Jason M. Shepard is the chairman of the Cobb County Republican Party and brings this action in his official capacity on behalf of the Cobb County Republican Party. 30. Plaintiff Brian J. Van Gundy is registered voter in Gwinnett County, Georgia. He is the Assistant Secretary of the Georgia Republican Party. 31. Defendant Governor Brian Kemp, Governor of Georgia, is named herein in his official capacity as Governor of the state of Georgia. On or about June 9, 2019, Governor Kemp bought the new Dominion voting systems for Georgia, budgeting $150 million for the machines. Critics are quoted, led by Abrams, Democrats fought the legislation and pointed to cybersecurity experts who warned it would leave Georgia's elections susceptible to hacking and tampering. And, just this week, the Fair Fight voting rights group started by Stacey Abrams launched a television ad critical of the bill. In a statement Thursday, the group called it, corruption at its worst, and a waste of money on, hackable voting machines. 7. 7. Georgia Governor Inc.'s law to replace voting machines. The Atlanta Journal-Constitution. AJC News Now. Credit. Copyright 2019. The Associated Press. June 2019. 14. 32. Defendant Brad Raffensperger, Secretary Raffensperger, is named herein in his official capacity as Secretary of State of the State of Georgia and the Chief Election Official for the State of Georgia pursuant to Georgia's Election Code and OCGA. Section the 21st of February 50. Secretary Raffensperger is a state official subject to suit in his official capacity because his office imbues him with the responsibility to enforce the election laws. Grizzle v. Kemp, 634. F. 3D 1314, 1319, 11th CIR. 2011. Secretary Raffensperger serves as the chairperson of Georgia's State Election Board, which promulgates and enforces rules and regulations to obtain uniformity in the practices and proceedings of election officials as well as legality and purity in all primaries and general elections, and be conducive to the fair, legal, and orderly conduct of primaries and general elections. COCGA. Sections the 30th of February 21d, the 31st of February 21, 21-2-33.1. Secretary Raffensperger, as Georgia's Chief Elections Officer, is further responsible for the administration of the state laws affecting voting, including the absentee voting system. COCGA. Section the 21st of February 50b. 33. Defendants Rebecca N. Sullivan, David J. Worley, Matthew Mashburn, and Ann La hereinafter the State Election Board are members of the State Election Board in Georgia, responsible for formulating, adopting, and promulgating such rules and regulations consistent with law, as will be 15. Conducive to the fair, legal, and orderly conduct of primaries and elections. OCGA. Section the 31st of February 21-2. Further, the State Election Board promulgate rules and regulations to define uniform and non-discriminatory standards concerning what constitutes a vote and what will be counted as a vote for each category of voting system in Georgia. OCGA. Section the 31st of February 21-7. The State Election Board, personally and through the conduct of the board's employees, officers, agents, and servants, acted under color of state law at all times relevant to this action and are sued for emergency declaratory and injunctive relief in their official capacities. Jurisdiction and venue. 34. This court has subject matter jurisdiction under 28 U.S.C. 1331, which provides, the district courts shall have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. 35. This court also has subject matter jurisdiction under 28 U.S.C. 1343. Because this action involves a federal election for President of the United States. A significant departure from the legislative scheme for appointing presidential electors presents a federal constitutional question. Bush v. Gore, 531 U.S. 98, 113 2000 Rehnquist, C.J., concurring, Smiley v. Home, 285 U.S. 355, 365 1932. 16. 36. The jurisdiction of the court to grant declaratory relief is conferred by 28 U.S.C. 2201 and 2202 and by Rule 57 and 65, Fed. R.Civ. P7. 37. This court has jurisdiction over the related Georgia constitutional claims and state law claims under 28 U.S.C. 1367. 38. In Georgia, the legislature is the General Assembly. Siga, Const. Art. 3, Section I, Para. I. 39. Because the United States Constitution reserves for state legislatures the power to set the time, place, and manner of holding elections for Congress and the President, state executive officers, including but not limited to Secretary Raffensperger, have no authority to exercise that power unilaterally, much less flout existing legislation or the Constitution itself. Statement of facts. 40. Plaintiffs bring this action under 42 U.S.C. Sections 1983 and 1988, and under Georgia law, OCGA. Section the 21st of February 522 to remedy deprivations of rights, 17. Privileges, or immunities secured by the Constitution and laws of the United States and to contest the election results. 41. The United States Constitution sets forth the authority to regulate federal elections. The Constitution provides. The times, places and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. U.S. Const. Art. I. Section 4, Elections Clause. 42. With respect to the appointment of presidential electors, the Constitution provides, each state shall appoint, in such manner as the legislature thereof may direct, a number of electors, equal to the whole number of senators and representatives to which the state may be entitled in the Congress, but no senator or representative, or person holding an office of trust or profit under the United States, shall be appointed an elector. U.S. Const. Art. 2, Section 1, Electors Clause. 43. Neither defendant is a legislature, as required under the Elections Clause or Electors Clause. The legislature is the representative body which casts the laws of the people. Smiley 285 U.S. 365. Regulations of congressional and presidential elections, thus, must be in accordance with 18. The method which the state has prescribed for legislative enactments. ID. At 367, see also ARES. State Legislature v. ARES. INDUP. Redistricting Common, 576. U.S. 787, 135 S. Court. 2652, 2668 U.S. 2015. 44. While the Elections Clause was not adopted to diminish a state's authority to determine its own lawmaking processes, ARI's State Legislature, 135 S. Court. At 2677, it does hold states accountable to their chosen processes when it comes to regulating federal elections, id. At 2668. A significant departure from the legislative scheme for appointing presidential electors presents a federal constitutional question. Bush, 531 U.S. at 113 Rehnquist, C.J., concurring, Smiley, 285 U.S. at 365. 45. Plaintiffs also bring this action under Georgia law, OCGA. Section the 21st of February 522, grounds for contest. A result of a primary or election may be contested on one or more of the following grounds. 1. Misconduct, fraud, or irregularity by any primary or election official or officials sufficient to change or place in doubt the result. 2. When the defendant is ineligible for the nomination or office in dispute. 3. When illegal votes have been received or legal votes rejected at the polls sufficient to change or place in doubt the result. 4. For any error in counting the votes or declaring the result of the primary or election, if such error would change the result, or 19. 5. For any other cause which shows that another was the person legally nominated, elected, or eligible to compete in a runoff primary or election. OCGA. Section the 21st of February 522. 46. Under OCGA. Section the 10th of February 21, presidential electors are elected. 47. Under OCGA. Section the 21st of February 386 ALB, the Georgia legislature instructed the county registrars and clerks, the county officials, to handle the absentee ballots as directed therein. The Georgia legislature set forth the procedures to be used by each municipality for appointing the absentee ballot clerks to ensure that such clerks would perform the duties set forth in this article. COCGA. Section 21-2-380.1. 48. The Georgia Election Code instructs those who handle absentee ballots to follow a clear procedure. Upon receipt of each absentee ballot, a registrar or clerk shall write the day and hour of the receipt of the ballot on its envelope. The registrar or clerk shall then compare the identifying information on the oath with the information on file in his or her office, shall compare the signature or make on the oath with the signature or mark on the absentee elector's voter card or the most recent update to such absentee elector's voter registration card, an application for absentee ballot or a facsimile of said signature or maker taken from said card or application, and shall, if the information and signature appear to be valid and other identifying information appears to be correct, so certify by signing or initialing his or her name below the 20. Voter's oath. Each elector's name so certified shall be listed by the registrar or clerk on the numbered list of absentee voters prepared for his or her precinct. OCGA. Section the 21st of February 386 ALB, emphasis added. 49. Under OCGA. Section the 21st of February 386 ALC, the Georgia legislature also established a clear and efficient process to be used by county officials if they determine that an elector has failed to sign the oath on the outside envelope enclosing the ballot or that the signature does not conform with the signature on file in the registrar's or clerk's office, a defective absentee ballot. 50. The Georgia legislature also provided for the steps to be followed by county officials with respect to defective absentee ballots. If the elector has failed to sign the oath, or if the signature does not appear to be valid, or if the elector has failed to furnish required information or information so furnished does not conform with that on file in the registrar's or clerk's office, or if the elector is otherwise found disqualified to vote, the registrar or clerk shall write across the face of the envelope, rejected, giving the reason therefor. The Board of Registrars or absentee ballot clerk shall promptly notify the elector of such rejection, a copy of which notification shall be retained in the files of the Board of Registrars or absentee ballot clerk for at least 1 year. OCGA. Section the 21st of February 386 ALC, emphasis added. 21. I. Defendants, unauthorized actions violated the Georgia Election Code and caused the processing of defective absentee ballots. 51. Notwithstanding the clarity of the applicable statutes and the constitutional authority for the Georgia legislature's actions, on March 6, 2020, the Secretary of State of the State of Georgia, Secretary Raffensperger, and the State Election Board, who administer the state elections, the administrators, entered into a compromise and settlement agreement and release the litigation settlement with the Democratic Party of Georgia, Inc., the Democrat Senatorial Campaign Committee, and the Democratic Congressional Campaign Committee, collectively, the Democrat Party agencies, setting forth different standards to be followed by the clerks and registrars in processing absentee ballots in the state of Georgia. 8. 52. Under the settlement, however, the administrators agreed to change the statutorily prescribed manner of handling absentee ballots in a manner that is not consistent with the laws promulgated by the Georgia legislature for elections in this state. 8C Democratic Party of Georgia, Inc., et al. V. Raffensperger, et al. Civil Action File Number 1, L9CV05028WMR, United States District Court for the Northern District of Georgia, Atlanta Division, Doc. 56-1. 22. 53. The settlement provides that the Secretary of State would issue an official election bulletin to county administrators overriding the statutory procedures prescribed for those officials. That power, however, does not belong to the Secretary of State under the United States Constitution. 54. The settlement also changed the signature requirement, reducing it to a broad process with discretion, rather than enforcement of the signature requirement as statutorily required under OCGA. The 21st of February 386 AL. 55. The Georgia legislature instructed county registers and clerks the county officials regarding the handling of absentee ballots in OCGA. S. The 21st of February 386 of 1B 21 to 2-380.1. The Georgia Election Code instructs those who handle absentee ballots to follow a clear procedure. Upon receipt of each absentee ballot, a registrar or clerk shall write the day and hour of the receipt of the ballot on its envelope. The registrar or clerk shall then compare the identifying information on the oath with the information on file in his or her office, shall compare the signature or make on the oath with the signature or mark on the absentee elector's voter card or the most recent update to such absent elector's voter registration card, an application for absentee ballot or a facsimile of said signature or maker taken from said card or application, and shall, if the information and signature appear to be valid and other identifying information appears to be correct, so certify by signing or initialing his or her name below the voter's oath. 23. OCGA. S. The 21st of February 386 of 1B. 56. The Georgia legislature prescribed procedures to ensure that any request for an absentee ballot must be accompanied by sufficient identification of the elector's identity. COCGA. Section the 21st of February 38 LB 1 providing, in pertinent part, in order to be found eligible to vote an absentee ballot in person at the registrar's office or absentee ballot clerk's office, such person shall show one of the forms of identification listed in Code Section the 21st of February 417. 57. An affiant testified, under oath, that it was also of particular interest to me to see that signatures were not being verified and that there were no corresponding envelopes seen in sight. Attached hereto is X. 10. Myra Romera, at par. 7. 58. To reflect the very reason for process, it was documented that in the primary election, prior to the November 3, 2020 presidential election, many ballots got to voters after the election. Further, it was confirmed that untold thousands of absentee ballot requests went unfulfilled, and tens of thousands of mailed ballots were rejected for multiple reasons, including arriving too late. 24. To be counted. See the Associated Press, Vote by Mail Worries, a leaky pipeline in many states, August 8, 2020. 9. 59. Pursuant to the settlement, the administrators delegated their responsibilities for determining when there was a signature mismatch by considering in good faith only partisan-based training, additional guidance and training materials, drafted by the Democrat Party agencies. Representatives contradicting OCGA. Section the 31st of February 21. B. Unlawful early processing of absentee ballots. 60. In April 2020, the State Election Board adopted on a purportedly emergency basis, Secretary of State Rule the 14th of January 183-0.9-.15, processing ballots prior to Election Day. Under this rule, county election officials are authorized to begin processing absentee ballots up to 3 weeks before Election Day. Thus, the rule provides in part that, 1. Beginning at 8 a.m. on the third Monday prior to Election Day, the county election superintendent shall be authorized to open the outer envelope of accepted absentee ballots, emphasis added. 9. https://apnews.com/article US News App Top News Election 2020 Technology Politics 52E87011F4D041BFFFCCD64FC87087 25. 61. Rule the 14th of January 183-0.9-.15 is in direct and irreconcilable conflict with OCGA. Section the 21st of February 386 A2, which prohibits the opening of absentee ballots until Election Day. After the opening of the polls on the day of the primary, election, or runoff, the registrars or absentee ballot clerks shall be authorized to open the outer envelope on which is printed the oath of the elector in such a manner as not to destroy the oath printed thereon, provided, however, that the registrars or absentee ballot clerk shall not be authorized to remove the contents of such outer envelope or to open the inner envelope marked, official absentee ballot, except as otherwise provided in this code section. Emphasis added. 62. In plain terms, the statute clearly prohibits opening absentee ballots prior to Election Day, while the rule authorizes doing so 3 weeks before Election Day. There is no reconciling this conflict. The State Election Board has authority under OCGA. Section the 31st of February 21 to adopt lawful and legal rules and regulations, but no authority to promulgate a regulation that is directly contrary to an unambiguous statute. Rule the 14th of January 183-0.9-.15 is therefore plainly and indisputably unlawful. 63. The State Election Board re-adopted Rule the 14th of January 183-0.9-.15 on November 23, 2020 for the upcoming January 2021 runoff election. 26. See Unlawful Audit Procedures. 64. According to Secretary Raffensperger, in the presidential general election, 2,457,880 votes were cast in Georgia for President Donald J. Trump, and 2,472,002 votes were cast for Joseph R. Biden, which narrowed in Donald Trump's favor after the most recent recount. 65. Secretary Raffensperger declared that for the hand recount, per the instructions given to counties as they conduct their audit-triggered full hand recounts, designated monitors will be given complete access to observe the process from the beginning. While the audit-triggered recount must be open to the public and media, designated monitors will be able to observe more closely. The general public and the press will be restricted to a public viewing area. Designated monitors will be able to watch the recount while standing close to the elections workers conducting the recount. Political parties are allowed to designate a minimum of 2 monitors per county at a ratio of 1 monitor per party for every 10 audit boards in a county. Beyond being able to watch to ensure the recount is conducted fairly and securely, the two-person audit boards conducting the hand recount call out the votes as they are recounted, providing monitors and the public an additional way to keep tabs on the process. 10. Office of Brad Raffensperger, monitors closely observing audit-triggered full hand recount. Transparency is built into process. https://sos.gov.gov/index.php elections monitors _closely _observing _audit-triggered _full _hand _recount _transparency is built into process. 27. 66. The audit was conducted OCGA. Section the 21st of February 498. This code section requires that audits be completed, in public view, and authorizes the State Board of Elections to promulgate regulations to administer an audit, to ensure that collection of validly cast ballots is complete, accurate and trustworthy throughout the audit. 67. Plaintiffs can show that Democrat-majority counties provided political parties and candidates, including the Trump campaign, no meaningful access or actual opportunity to review and assess the validity of mail-in ballots during the pre-canvassing meetings. While in the audit or recount, they witnessed Trump votes being put into Biden piles. 68. Non-parties Amanda Coleman and Maria Diedrich are two individuals who volunteered to serve as designated monitors for the Donald J. Trump Presidential Campaign, Inc. The Trump campaign, on behalf of the Georgia Republican Party, the Republican Party, at the hand recount. Attached hereto and incorporated herein as Exhibits 2 and 3 respectively, are true and correct copies of 1. The affidavit of Amanda Coleman in support of plaintiff's motion for temporary restraining order, the Coleman affidavit, and 2. The affidavit of Maria Diedrich in support of plaintiffs. 28. Motion for temporary restraining order, the Diedrich affidavit. CX. 11, Coleman Aff. 2, X. 12, Diedrich Aff. 2, 69. The affidavits set forth various conduct amounting to federal crimes, clear improprieties, insufficiencies, and improper handling of ballots by county officials and their employees that M. Wise Coleman and M. Wise Diedrich personally observed while monitoring the hand recount. CX. 11, Coleman Aff. 3 to 10, X. 12, Diedrich Aff. 4 to 14, 70. As a result of her observations of the hand recount as a Republican Party monitor, M. Wise Diedrich declared, there had been no meaningful way to review or audit any activity at the hand recount. CX. 12, Diedrich Aff. 14, 71. As a result of their observations of the hand recount as Republican Party monitors, M. Wise Coleman likewise declared, there was no way to tell if any counting was accurate or if the activity was proper. CX. 12, Coleman Aff. 10, 72. On Election Day, when the Republican poll watchers were, for a limited time, present and allowed to observe in various polling locations, they 29. Observed and reported numerous instances of election workers failing to follow the statutory mandates relating to two critical requirements, among other issues. 1. A voter's right to spoil their mail-in ballot at their polling place on Election Day and to then vote in person, and 2. The ability for voters to vote provisionally on Election Day when a mail-in ballot has already been received for them, but when they did not cast those mail-in ballots, who sought to vote in person during early voting but was told she already voted, she emphasized that she had not. The clerk told her he would add her manually with no explanation as to who or how someone voted using her name. Attached hereto is X. 13, Aff. Ursula Wolf. 73. Another observer for the ballot recount testified that, at no time did I witness any recounter or individual participate in the recount verifying signatures on mail-in ballots. Attached hereto is X. 14, Nicholas Zeher Aff. 74. In some counties, there was no actual, hand, recounting of the ballots during the hand recount, but rather, county officials and their employees 30. Simply conducted another machine count of the same ballots. C. X. 9, 10. That will not reveal the massive fraud of which plaintiffs complain. 75. A large number of ballots were identical and likely fraudulent. An affiant explains that she observed a batch of utterly pristine ballots, 14. Most of the ballots had already been handled, they had been written on by people, and the edges were worn. They showed obvious use. However, one batch stood out. It was pristine. There was a difference in the texture of the paper, it was if they were intended for absentee use but had not been used for that purposes. There was a difference in the feel. 15. These different ballots included a slight depressed pre-fold so they could be easily folded and unfolded for use in the scanning machines. There were no markings on the ballots to show where they had come tilde from, or where they had been processed. These stood out. 16. In my 20 years of experience of handling ballots, I observed that the markings for the candidates on these ballots were unusually uniform, perhaps even with a ballot marking device. By my estimate in observing these ballots, approximately 98% constituted votes for Joe Biden. I only observed 2 of these ballots as votes for President Donald J. Trump. CX. 15 attached hereto. 76. The same affiant further testified specifically to the breach of the chain of custody of the voting machines the night before the election, stating, we typically receive the machines, the ballot marking devices, on the Friday before the election, with a chain of custody letter to be signed on Sunday, indicating that we had received the machines and the counts on the machines when received, and that the machines have been sealed. In this case, we were asked to sign the chain of custody letter on Sunday, even though the machines were not delivered until 2 a.m. in the morning on Election Day. 31. The Milton precinct received its machines at 1 a.m. in the morning on Election Day. This is unacceptable and voting machines should not be out of custody prior to an election day. ID. 2. Evidence of fraud. A pattern showing the absence of mistake. 77. The stunning pattern of the nature and acts of fraud demonstrate an absence of mistake. 78. The same affiant further explained, in sworn testimony, that the breach included, when we did receive the machines, they were not sealed or locked, the serial numbers were not what were reflected on the related documentation, CID 79. An affiant testified that, while in Henry County, I personally witnessed ballots cast for Donald Trump being placed in the pile for Joseph Biden. I witnessed this happen at table A. CX 14, par 27. 80. The affiant further testified that, when this was brought to M. Wise Pitt's attention, it was met with extreme hostility. At no time did I witness any ballot cast for Joseph Biden be placed in the pile for Donald Trump. CX 14, par 28. 32. 81. Another affiant in the mail-in ballot and absentee ballot recounting process testified in her sworn affidavit that, on November 16, 2020, it was also of particular interest to me to see that signatures were not being verified and there were no corresponding envelopes seen in sight. CX 10, at par 7. 82. Yet another affiant, in the recount process, testified that he received pushback and a lack of any cooperation and was even threatened as if he did something wrong, when he pointed out the failure to follow the rules with the observers while open mail-in ballot recounting was occurring, stating, "However, as an observer, I observed that the precinct had 12 counting tables, but only one monitor from the Republican Party. I brought it up to Erica Johnston since the recount rules provided for one monitor from each party per 10 tables or part thereof." See attached here 2, X. 16, Ibrahim Reyes F. 83. Another affiant explains a pattern of behavior that is alarming. In his position as an observer in the recount on absentee ballots with barcodes, he testified, "I witnessed 2 poll workers placing already separated paper machine receipt ballots with barcodes in the Trump tray, placing them into the Biden tray. I also witnessed the same 2 poll workers putting the already separated paper receipt BA lots in 33. The no vote and Jorgensen tray and removing them and putting them inside the Biden tray. They then took out all of the ballots out of the Biden tray and stacked them on the table, writing on the count ballot sheet. See attached here 2, X. 17, pars 4 to 5, F. Of Concetta Johnson. 84. Another affiant, a Democrat, testified in his sworn affidavit that before he was forced to move back to where he could not see, he had in fact seen absentee ballots for Trump inserted into Biden's stack and counted as Biden votes. This occurred a few times. See attached here 2, X. 18 at par 12, F. Of Carlos Silva. 85. Yet another affiant testified about the lack of process and the hostility only towards the Republican Party, which is a violation of the Equal Protection Clause. He testified, "I also observed throughout my 3 days in Atlanta, not once did anyone verify these ballots. In fact, there was no authentication process in place and no envelopes were observed or allowed to be observed. I saw hostility towards Republican observers but never towards Democrat observers. Both were identified by badges." CID, at pars 13 to 14. 86. Another affiant explained that his ballot was not only not processed in accordance with election law, he witnessed people reviewing his ballot to decide where to place it, which violated the privacy of his ballot, and when he 34 tried to report it to a voter fraud line, he never received any contact or cooperation, stating, "I voted early on October 12 at the precinct at Linwood Park. Because of irregularities at the polling location, I called the voter fraud line to ask why persons were discussing my ballot and reviewing it to decide where to place it. When I called the state fraud line, I was directed to a worker in the office of the Secretary of State." See attached here 2, X. 19, Andrea O'Neill F. at par 3. 87. He further testified that when he was an observer at the Lithonia location, he saw many irregularities, and specifically, saw an auditor sort Biden votes that he collected and sorted into 10 ballot stacks, which the auditor did not show anyone. ID, at p. 8. 88. Another affiant testified about the use of different paper for ballots that would constitute fraud, stating, "I noticed that almost all of the ballots I reviewed were for Biden. Many batches went 100% for Biden. I also observed that the watermark on at least 3 ballots were solid gray instead of transparent, leading me to believe the ballot was counterfeit. I challenged this and the elections director said it was a legitimate ballot and was due to the use of different printers. Many ballots had markings for Biden only, and no markings on the rest of the ballot." See attached here 2, X. 20, F. of Deborah J. Fisher, at pars 4, 5, 6. 35. 89. An affiant testified that while at the audit, while in Henry County, I personally witnessed ballots cast for Donald Trump being placed in the pile for Joseph Biden. I witnessed this happen at table A. See attached here 2 as X. 22, Kevin Peterford, at par 29. Another affiant testified that I witnessed 2 poll workers placing already separated paper machine receipt ballots with barcodes in the Trump tray, placing them into the Biden tray. I also witnessed the same 2 poll workers putting the already separated paper receivable lots in the no vote and Jorgensen tray and removing them and putting them inside the Biden tray. They then took out all of the ballots out of the Biden tray and stacked them on the table, writing on the count ballot sheet. CX 17, Johnson, pars 4 to 5. 90. Another affiant, a Democrat, testified in his sworn affidavit, before he was forced to move back to where he could not see, he had in fact seen, I also saw absentee ballots for Trump inserted 36 into Biden's stack and counted as Biden votes. This occurred a few times. CX 18, par 12. 91. A Republican National Committee monitor in Georgia's election recount, Hale Soki, told an undercover journalist there are individuals counting ballots who have made continuous errors, writes O'Keefe. Project Veritas, watch, latest Project Veritas video reveals, multiple ballots meant for Trump went to Biden in Georgia. 11. B. The voting machines, secrecy. Software used by voting machines throughout Georgia is crucial. 92. These violations of federal and state laws impacted the election of November 3, 2020 and set the predicate for the evidence of deliberate fraudulent conduct, manipulation, and lack of mistake that follows. The commonality and statewide nature of these legal violations renders certification of the legal vote untenable and warrants immediate 11. https://hannity.com/media room watch latest Project Veritas video reveals multiple ballots meant for Trump went to Biden in Georgia. 37. Impoundment of voting machines and software used throughout Georgia for expert inspection and retrieval of the software. 93. An affiant, who is a network and information cybersecurity expert, under sworn testimony explains that after studying the user manual for Dominion Voting Systems democracy software, he learned that the information about scanned ballots can be tracked inside the software system for Dominion. A. When bulk ballot scanning and tabulation begins, the ImageCast Central workstation operator will load a batch of ballots into the scanner feed tray and then start the scanning procedure within the software menu. The scanner then begins to scan the ballots which were loaded into the feed tray while the ImageCast Central software application tabulates votes in real time. Information about scanned ballots can be tracked inside the ImageCast Central software application. See attached here 2x22, Declaration of Ronald Watkins, at par. 11. 94. Affiant further explains that the central operator can remove or discard batches of votes. After all of the ballots loaded into the scanner's feed tray have been through the scanner, the ImageCast Central operator will remove the ballots from the tray, then have the option to either accept batch or discard batch on the scanning menu. ID at par 8. 38. 95. Affiant further testifies that the Dominion Smartmatic user manual itself makes clear that the system allows for threshold settings to be set to mark all ballots as problem ballots for discretionary determinations on where the vote goes. It states, during the scanning process, the ImageCast Central software will detect how much of a percent coverage of the oval was filled in by the voter. The Dominion customer determines the thresholds of which the oval needs to be covered by a mark in order to qualify as a valid vote. If a ballot has a marginal mark which did not meet the specific threshold set by the customer, then the ballot is considered a problem ballot and may be set aside into a folder named Notcast Images. Through creatively tweaking the oval coverage threshold settings, it should be possible to set thresholds in such a way that a non-trivial amount of ballots are marked problem ballots and sent to the Notcast Images folder. It is possible for an administrator of the ImageCast Central workstation to view all images of scanned ballots which were deemed problem ballots by simply navigating via the standard Windows File Explorer to the folder named Notcast Images, which holds ballot scans of problem ballots. It is possible for an administrator of the ImageCast Central workstation to view and delete any individual ballot scans from the Notcast Images folder by simply using the standard Windows Delete and Recycle Bin functions provided by the Windows 10 Pro operating system. ID at pars 9 to 10. 96. The affiant further explains the vulnerabilities in the system when the copy of the selected ballots that are approved in the results folder are made 39 to a flash memory card, and that is connected to a Windows computer, stating, it is possible for an administrator of the ImageCast Central workstation to view and delete any individual ballot scans from the Notcast Images folder by simply using the standard Windows Delete and Recycle Bin functions provided by the Windows 10 Pro operating system. The upload process is just a simple copying of a results folder containing vote tallies to a flash memory card connected to the Windows 10 Pro machine. The copy process uses the standard drag and drop or copy-paste mechanisms within the ubiquitous Windows File Explorer. While a simple procedure, this process may be error-prone and is very vulnerable to malicious administrators. ID at par 11 to 13, emphasis supplied. 97. It was announced on Monday, July 29, 2019, that Governor Kemp awarded a contract for 30,000 new voting machines to Dominion Voting Systems, scrapping the state's 17-year-old electronic voting equipment and replacing it with touchscreens that print out paper ballots. 12 critics are quoted. Led by Abrams, Democrats fought the legislation and pointed to cybersecurity experts who warned it would leave Georgia's elections susceptible to hacking and tampering. And, just this week, the Fair Fight voting rights group started by Stacey Abrams launched a television ad 12 Georgia buys new voting machines for 2020 presidential election, by Mark Neas, The Atlanta Journal-Constitution, July 30, 2019, https://www.ajc.com/news state regional gov. Politics Georgia awards contract for new election system Dominion voting THH3V8 Kazjavivzerlo 40. 40. Critical of the bill. In a statement Thursday, the group called it corruption at its worst and a waste of money on hackable voting machines. 13. 98. It was further reported in 2019 that the new Dominion voting machines in Georgia, WITH Georgia's current voting system, there's no way to guarantee that electronic ballots accurately reflect the choices of voters because there's no paper backup to verify results, with it being reported that A. Recounts are meaningless on the direct recording electronic voting machines because they simply reproduce the same numbers they originally generated. B. But paper ballots alone won't protect the sanctity of elections on the new touchscreens called ballot marking devices. C. The new election system depends on voters to verify the printed text of their choices on their ballots, a step that many voters might not take. The state election board hasn't yet created regulations for how recounts and audits will be conducted. And paper ballots embed selections in barcodes that are only readable by scanning machines, leaving Georgians uncertain whether the barcodes match their votes. 14. 13. Georgia Governor inks law to replace voting machines. The Atlanta Journal-Constitution, AJC News Now, by Greg Bluestein and Mark Nias, June 14, 2019. Credit. Copyright 2019 The Associated Press, June 2019. 41. As part of the scheme and artifice to defraud the plaintiffs, the candidates and the voters of undiminished and unaltered voting results in a free and legal election, the defendants and other persons known and unknown committed the following violations of law. 50 U.S.C. Section 20701 requires the retention and preservation of records and papers by officers of elections under penalty of fine and imprisonment. Section 20701. Retention and preservation of records and papers by officers of elections, deposit with custodian, penalty for violation. Every officer of election shall retain and preserve, for a period of 22 months from the date of any general, special, or primary election of which candidates for the office of President, Vice President, Presidential Elector, Member of the Senate, Member of the House of Representatives, or Resident Commissioner from the Commonwealth of Puerto Rico are voted for, all records and papers which come into his possession relating to any application, registration, payment of poll tax, or other act requisite to voting in such election, except that, when required by law, such records and papers may be delivered to another officer of election, and except that, if a state or the Commonwealth of Puerto Rico designates a custodian to retain and preserve these records and papers at a specified place, then such records and papers may be deposited with such custodian, and the duty to retain and preserve any record or paper so deposited shall devolve upon such custodian. Any officer of election or custodian who willfully fails to comply with this section shall be fined not more than $1,000 or imprisoned not more than 1 year, or both. 50 U.S.C. Section 20701. 99. In the primaries it was confirmed that the rapid introduction of new technologies and processes in state voting systems heightens the risk of 42. Foreign interference and insider tampering. That's true even if simple human error or local maneuvering for political advantage are more likely threats. 15. 100. A Penn Wharton study from 2016 concluded that voters and their representatives in government, often prompted by news of high-profile voting problems, also have raised concerns about the reliability and integrity of the voting process and have increasingly called for the use of modern technology such as laptops and tablets to improve convenience. 16. 101. As evidence of the defects or features of the Dominion Democracy Suite, as described above, the same Dominion Democracy Suite was denied certification in Texas by the Secretary of State on January 24, 2020. Specifically because of a lack of evidence of efficiency and accuracy and to be safe from fraud or unauthorized manipulation. 17. 15 C threats to Georgia elections loom despite new paper ballot voting, by Mark Nias, The Atlanta Journal-Constitution and the AP, Vote by Mail Worries, a leaky pipeline in many states, August 8, 2020. 16 Penn Wharton study by Matt Cofield, The Business of Voting, July 2018. 17 attached here 2, X. 23, copy of Report of Review of Dominion Voting Systems Democracy Suite 5.5-A Elections Division by the Secretary of State's Office, Elections Division, January 24, 2020. 43. 102. Plaintiffs have since learned that the glitches in the Dominion system that have the uniform effect of taking votes from Trump and shifting them to Biden have been widely reported in the press and confirmed by the analysis of independent experts. 103. Plaintiffs can show, through expert and fact witnesses, that c. Dominion Smartmatic systems have massive end-user vulnerabilities. 1. Users on the ground have full admin privileges to machines and software. Having been created to rig elections, the Dominion system is designed to facilitate vulnerability and allow a select few to determine which votes will be counted in any election. Workers were responsible for moving ballot data from polling place to the collector's office and inputting it into the correct folder. Any anomaly, such as pen drips or bleeds, results in a ballot being rejected. It is then handed over to a poll worker to analyze and decide if it should count. This creates massive opportunity for purely discretionary and improper vote adjudication. 2. Affiant witness name redacted for security reasons. 18 in his sworn testimony explains he was selected for the National Security Guard detail of the President of Venezuela, and that he witnessed the creation of Smartmatic for the purpose of election vote manipulation to ensure Venezuelan dictator Hugo Chavez never lost an election, and he saw it work. ID. The purpose of this conspiracy was to create and operate a voting system that could change the votes in elections from votes against. 44. Persons running the Venezuelan government to votes in their favor in order to maintain control of the government. CX. 2, Pars. 6, 9, 10. 104. Smartmatic's incorporators and inventors have backgrounds evidencing their foreign connections, including Venezuela and Serbia, specifically its identified inventors. Applicant, Smartmatic, Corp. Inventors, Lino Iglesias, Roger Panate, Antonio Mujica, Paul Babbage, Jeffrey Navita, Danny Farina, Rodrigo Meneses, Salvador Ponticelli, Gisela Goncalves, Iram Caruso. 19. 105. The presence of Smartmatic in the United States, owned by foreign nationals, and Dominion, a Canadian company with its offices such as the Office of General Counsel in Germany, would have to be approved by CFI-US. CFI-US was created in 1988 by the Ex Florio Amendment to the Defense Production Act of 1950. CFIUS, authorizing statute was amended by the Foreign Investment and National Security Act of 2007 FINSA. As amended, Section 721 of the DPA directs the President, acting through CFIUS, to review a covered transaction to determine the effects of the transaction on the national security of the United States. 50 U.S.C. App. Section 2170b1a. Section 721 defines 19 https://patents.justia.com/assignee Smartmatic Corp. 45. A covered transaction is any merger, acquisition, or takeover by or with any foreign person which could result in foreign control of any person engaged in interstate commerce in the United States. ID. Section 2170 A3. Rawls Corp. V. Com. On Foreign INV. 758 F3D 296, 302, 411 U.S. App. DC. 105, 111, 2014. Review of covered transactions under Section 721 begins with CFIUS. As noted, CFIUS is chaired by the Treasury Secretary and its members include the heads of various federal agencies and other high-ranking government officials with foreign policy, national security and economic responsibilities. 106. Then Congresswoman Carolyn Maloney wrote October 6, 2006 to the Secretary of Treasury, Henry M. Paulson Jr., objecting to approval of Dominion Smartmatic by CFIUS because of its corrupt Venezuelan origination, ownership and control. See attached here too as X. 24, Carolyn Maloney letter of October 6, 2006. Our own government has long known of this foreign interference on our most important right to vote, and it had either responded with incompetence, negligence, willful blindness, or abject corruption. In every CFIUS case, there are two TSXI reports generated. One by the ODNI on the threat and one by DHS on risk to critical infrastructure. Smartmatic was a known problem when it was nonetheless approved by CFIUS. 107. The Wall Street Journal in 2006 did an investigative piece and found that Smartmatic came to prominence in 2004 when its machines were used 46. In an election to recall President Chavez, which Mr. Chavez won handily, and which the Venezuelan opposition said was riddled with fraud. Smartmatic put together a consortium to conduct the recall elections, including a company called Vista Corp, in which Smartmatic owners had a large stake. For a time, the Venezuelan government had a 28% stake in Vista in exchange for a loan. 20. Vista paid off the loan in 2004, and Smartmatic bought the company the following year. But accusations of Chavez government control of Smartmatic never ended, especially since Smartmatic scrapped a simple corporate structure, in which it was based in the U.S. with a Venezuelan subsidiary, for a far more complex arrangement. The company said it made the change for tax reasons, but critics, including Rep. Carolyn Maloney D. N.Y. and TV journalist Lou Dobbs, pounded the company for alleged links to the Chavez regime. ID. Since its purchase by Smartmatic, Sequoia's sales have risen sharply to a projected $200 million in 2006, said Smartmatic's chief executive, Anthony Mujica. ID. 108. Indeed, Mr. Kobuchi testified, through his sworn affidavit, that he born in Venezuela, is cousins with Antonio Anthony Mujica, and he has 20 CWSJ.com, Smartmatic to sell U.S. unit, end probe into Venezuelan links, by Bob Davis, December 22, 2006, https://www.wsj.com/articles SB116674617078557263. 47. Personal knowledge of the fact that Anthony Mujica incorporated Smartmatic in the U.S. in 2000 with other family members in Venezuela listed as owners. He also has personal knowledge that Anthony Mujica manipulated Smartmatic to ensure the election for Chavez in the 2004 referendum in Venezuela. He also testified, through his sworn affidavit, that Anthony Mujica received tens of millions of dollars from 2003-2015 from the Venezuelan government to ensure Smartmatic technology would be implemented around the world, including in the U.S. See attached here too, X. 25, Juan Carlos Kobuchi F. 109. Another affiant witness testifies that in Venezuela, she was in an official position related to elections and witnessed manipulations of petitions to prevent a removal of President Chavez, and because she protested, she was summarily dismissed. Corroborating the testimony of our secret witness, and our witness Mr. Kobuchi, cousin of Anthony Mujica, who began Smartmatic, and this witness explains the vulnerabilities of the electronic voting system and Smartmatica to such manipulations. CX. 3. Diaz Cardozo F. 110. Specific vulnerabilities of the systems in question that have been documented or reported include 48. A. Barcodes can override the voter's vote. As one University of California, Berkeley study shows, in all three of these machines including Dominion voting systems, the ballot marking printer is in the same paper path as the mechanism to deposit marked ballots into an attached ballot box. This opens up a very serious security vulnerability. The voting machine can make the paper ballot to add votes or spoil already cast votes after the last time the voter sees the paper, and then deposit that marked ballot into the ballot box without the possibility of detection. CX. 7. 21. B. Voting machines were able to be connected to the internet by way of laptops that were obviously internet accessible. If one laptop was connected to the internet, the entire precinct was compromised. C. We discovered that at least some jurisdictions were not aware that their systems were online, said Kevin Skoglund, an independent security consultant who conducted the research with 9 others, all of them longtime security professionals and academics with expertise in election security. Vice. August 2019. 22. 21 ballot marking devices. BMDs cannot assure the will of the voters. Andrew W. Apple, Richard T. DeMillo, University of California, Berkeley, December 27, 2019. 22 exclusive. Critical U.S. election systems have been left exposed online despite official denials. Motherboard Tech by Vice, by Kim Zetter, August 8, 2019. https://www.vice.com/n article 3kxzk9 exclusive critical US election systems have been left exposed online despite official denials. 49. D. October 6, 2006 Congresswoman Carolyn Maloney called on Secretary of Treasury Henry Paulson to conduct an investigation into Smartmatic based in its foreign ownership and ties to Venezuela. CX. 24E. Congresswoman Maloney wrote that, it is undisputed that Smartmatic is foreign-owned and it has acquired Sequoia Smartmatica. Now acknowledged that Antonio Mujica, a Venezuelan businessman, has a controlling interest in Smartmatica, but the company has not revealed who all other Smartmatic owners are. ID. F. Dominion got into trouble with several subsidiaries it used over alleged cases of fraud. One subsidiary is Smartmatic, a company that has played a significant role in the U.S. market over the last decade. According to a report published by UK-based AccessWire 23. G. Litigation over Smartmatic glitches alleges they impacted the 2010 and 2013 midterm elections in the Philippines, raising questions of cheating and fraud. An independent review of the source codes used in the machines found multiple problems, which concluded the software. 23 voting technology companies in the U.S., their histories and present contributions. AccessWire, August 10, 2017, https://www.accesswire.com/471912/voting technology companies in the U.S., their histories. 50. Inventory provided by Smartmatic is inadequate, which brings into question the software credibility. 24. H. Dominion acquired Sequoia Voting Systems as well as Premier Election Solutions, formerly part of Diebold, which sold Premier to ES&S in 2009, until antitrust issues forced ES&S to sell Premier, which then was acquired by Dominion. 25. I. Dominion entered into a 2009 contract with Smartmatic and provided Smartmatic with the PCOS machines, optical scanners that were used in the 2010 Philippine election, the biggest automated election run by a private company. The international community hailed the automation of that first election in the Philippines. 26. The results. Transmission reached 90% of votes 4 hours after polls closed and Filipinos knew for the first time who would be their new president on Election Day. In keeping with local election law requirements, Smartmatic and Dominion were required to provide the source code of 24 Smartmatic TIM running out of time to fix glitches. ABS CBN News, May 4, 2010. https://news.abs-cbn.com/nation, the 4th of May 10, Smartmatic TIM running out time fix glitches. 25. The business of voting, Penn Warden, Cofield, p. 16. 26. Smartmatic TIM running out of time to fix glitches. ABS CBN News, May 4, 2010. https://news.abs-cbn.com/nation, the 4th of May 10, Smartmatic TIM running out time fix glitches. 51. The voting machines prior to elections so that it could be independently verified. 27. J. In late December of 2019, 3 Democrat senators, Warren, Klobuchar, Wyden, and House member Mark Pocan wrote about their particularized concerns that secretive and trouble-plagued companies have long skimped on security in favor of convenience, in the context of how they described the voting machine systems that 3 large vendors, Election Systems and Software, Dominion Voting Systems, and Hart InterCivic, collectively provide voting machines and software that facilitate voting for over 90% of all eligible voters in the U.S. See attached here too as X. 26. Copy of Senator Warren, Klobuchar, Wyden's December 6, 2019 letter. K. Senator Ron Wyden, D. Oregon, said the findings insecurity of voting systems are yet another damning indictment of the profiteering election vendors who care more about the bottom line than protecting our democracy. It's also an indictment, he said, of the notion that important cybersecurity decisions should be left entirely to County 27. Presumably the Machians were not altered following submission of the code. London, England. ACCESSWIRE, August 10, 2017, voting technology companies in the U.S. Their histories and present contributions. 52. Election offices, many of whom do not employ a single cybersecurity specialist. 28. 111. An analysis of the Dominion software system by a former U.S. military intelligence expert concludes that the system and software have been accessible and were certainly compromised by rogue actors, such as Iran and China. By using servers and employees connected with rogue actors and hostile foreign influences combined with numerous easily discoverable leaked credentials, Dominion neglectfully allowed foreign adversaries to access data and intentionally provided access to their infrastructure in order to monitor and manipulate elections, including the most recent one in 2020. CX. 7. 112. An expert witness in pending litigation in the United States District Court, Northern District Court of Georgia, Atlanta Div. 17 CV 02989. Specifically testified to the acute security vulnerabilities, among other facts, by declaration filed on October 4, 2020, CX. 4B, document 959-4. 28 exclusive. Critical U.S. election systems have been left exposed online despite official denials. Motherboard Tech by Vice, by Kim Zetter, August 8, 2019. https://www.vice.com/n article 3kxzk9 exclusive critical US election systems have been left Exposed online despite official denials. 53. Attached here 2, paragraph 18 and 20 of p. 28, x. 4, Hersty Declaration. Wherein he testified are found. 1. The failure of the Dominion software to meet the methods and processes for national standards for managing voting system problems and should not be accepted for use in a public election under any circumstances. 2. In Hersty's declaration he explained that there is evidence of remote access and remote troubleshooting which presents a grave security implication and certified identified vulnerabilities should be considered an extreme security risk, ID. Hari Hersty also explained that USB drives with vote tally information were observed to be removed from the presence of poll watchers during a recent election. ID. The fact that there are no controls of the USB drives was seen the lack of physical security and compliance with professional standards, in one Georgia county, where it is reported that 3,300 votes were found on memory sticks not loaded, plus in Floyd County, another 2,600 were unscanned, and the found votes reduced Biden's lead over Donald Trump 29. A. In the prior case against Dominion, Supra, further implicating the secrecy behind the software used in Dominion systems, 29 recount find thousands of Georgia votes, Atlanta Journal-Constitution by Mark Nias and David Wickert, November 19, 20. https://www.ajc.com/politics recount finds thousands of Georgia votes missing from initial counts ERDRNXPH3REQTM4SOINPSEP72M. 54. Dr. Eric Coomer, a vice president of Dominion Voting Systems, testified that even he was not sure of what testing solutions were available to test problems or how that was done. I have got to be honest, we might be a little bit out of my bounds of understanding the rules and regulations, and in response to a question on testing for voting systems problems in relation to issues identified in 2 counties, he explained that, Your Honor, I'm not sure of the complete test plan. Again, Pro V and V themselves determine what test plan is necessary based on their analysis of the code itself. ID. At document 959-4, pages 53, 62L.25p. 63L3. 113. Hersty stated within said declaration. The security risks outlined above, operating system risks, the failure to harden the computers, performing operations directly on the operating systems, lax control of memory cards, lack of procedures, and potential remote access are extreme and destroy the credibility of the tabulations and output of the reports coming from a voting system. See paragraph 49 of Hersty Declaration. 114. Rather than engaging in an open and transparent process to give credibility to Georgia's brand new voting system, the election processes were 55. Hidden during the receipt, review, opening, and tabulation of those votes in direct contravention of Georgia's election code and federal law. 115. The House of Representatives passed H.R. 2722 in an attempt to address these very risks identified by Hersty. On June 27, 2019, this bill addresses election security through grant programs and requirements for voting systems and paper ballots. The bill establishes requirements for voting systems, including that systems 1. Use individual, durable, voter-verified paper ballots. 2. Make a voter's marked ballot available for inspection and verification by the voter before the vote is cast. 3. Ensure that individuals with disabilities are given an equivalent opportunity to vote, including with privacy and independence, in a manner that produces a voter-verified paper ballot. 4. Be manufactured in the United States. And 5. Meet specified cybersecurity requirements, including the prohibition of the connection of a voting system to the Internet. Additional specific fraud. 116. On November 4, 2020, the Georgia GOP chairman issued the following statement. Let me repeat. Fulton County elections officials told the media and our observers that they were shutting down the tabulation center at State Farm Arena at 10:30 p.m. on election night to continue counting ballots in secret until 1 a.m. 30. 56. 117. It was widely reported that, as of 7 p.m. on Wednesday, Fulton County elections officials said 30,000 absentee ballots were not processed due to a pipe burst. 31 officials reassured voters that none of the ballots were damaged and the water was quickly cleaned up. But the emergency delayed officials from processing ballots between 5:30 a.m. and 9:30 a.m. Officials say they continued to count beginning at 8:30 a.m. Wednesday. The statement from Fulton County continues. Tonight, Fulton County will report results for approximately 86,000 absentee ballots, as well as Election Day and early voting results. These represent the vast majority of ballots cast within Fulton County. As planned, Fulton County will continue to tabulate the remainder of absentee ballots over the next 2 days. Absentee ballot processing requires that each ballot is opened, signatures verified, and ballots scanned. This is a labor-intensive process that takes longer to tabulate than other forms of voting. Fulton County did not anticipate having all absentee ballots processed on Election Day. Officials said they will work to ensure every vote is counted and all laws and regulations are followed. 32. 31. 4,000 remaining absentee ballots being counted in Fulton County, Fox 5 Atlanta, November 3, 2020, https://www.fox5atlanta.com/news pipe burst at State Farm Arena delays absentee ballot processing. 32. 4,000 remaining absentee ballots being counted in Fulton County, Fox 5 Atlanta, November 3, 2020, https://www.fox5atlanta.com/news pipe burst at State Farm Arena delays absentee ballot processing. 57. 118. Plaintiffs have learned that the representation about a water leak affecting the room where absentee ballots were counted was not true. The only water leak that needed repairs at State Farm Arena from November 3rd. November 5th was a toilet overflow that occurred earlier on November 3rd. It had nothing to do with a room with ballot counting, but the false water break representation led to everyone being sent home. Nonetheless, first 6 people, then 3 people stayed until 1:05 a.m. working on the computers. 119. An affiant recounts how she was present at State Farm Arena on November 3rd and saw election workers remaining behind after people were told to leave. CX 28, affidavit of Mitchell Harrison, X 29, affid of Michelle Brandon. 120. Plaintiffs have also learned through several reports that in 2010 Eric Coomer joined Dominion as vice president of U.S. Engineering. According to his bio, Coomer graduated from the University of California, Berkeley with a Ph.D. in nuclear physics. Eric Coomer was later promoted to Voting Systems Officer of Strategy and Security, although Coomer has since been removed from the Dominion page of directors. Dominion altered its website after 58. Colorado resident Joe Oltmann disclosed that as a reporter he infiltrated Antifa, a domestic terrorist organization where he recorded Eric Coomer representing, "Don't worry. Trump won't win the election, we fixed that," as well as social media posts with violence threatened against President Trump. See Joe Oltmann interview with Michelle Malkin dated November 13, 2020. Which contains copies of Eric Coomer's recording and tweets. 33. 121. While the bedrock of American elections has been transparency, almost every crucial aspect of Georgia's November 3, 2020, general election was shrouded in secrecy, rife with errors, and permeated with anomalies so egregious as to render the results incapable of certification. Multiple expert reports and statistical analyses prove hundreds of thousands of votes were lost or shifted that cost President Trump and the Republican candidates of Congressional Districts 6 and 7 their races. 122. As evidenced by numerous public reports, expert reports, and witness statements, defendants' egregious misconduct has included ignoring legislative mandates concerning mail-in and ordinary ballots and led to 33 Malkin Live. Election Update, interview of Joe Oltmann, by Michelle Malkin, November 13, 2020, available at https://www.youtube.com/watch. V equals DH1X4S9 Hulu and FBCLID equals IWER2EAJC1M9RT3 Doraj Psychum. 0 UPKB3 underscore MHH6 Migray 3 VNMLCTSHXF4. 59. Disenfranchisement of an enormous number of Georgia voters. Plaintiffs' experts can show that, consistent with the above specific misrepresentations, analysis of voting data reveals the following. A. Regarding uncounted mail ballots, based on evidence gathered by Matt Brainerd in the form of recorded calls and declarations of voters, and analyzed by plaintiffs' expert, Williams M. Briggs, Ph.D., shows, based on a statistically significant sample, that the total number of mail ballots that voters mailed in, but were never counted, have a 95% likelihood of falling between 31,559 and 38,886 total lost votes. This range exceeds the margin of loss of President Trump of 12,670 votes by at least 18,889 lost votes and by as many as 26,196 lost votes. CX 1. Dr. Briggs' report, with attachments. B. Plaintiff's expert also finds that voters received tens of thousands of ballots that they never requested. CX 1. Specifically, Dr. Briggs found that in the state of Georgia, based on a statistically significant sample, the expected amount of persons that received an absentee ballot that they did not request ranges from 16,938 to 22,771. This range exceeds the margin of loss of 60. President Trump by 12,670 votes by at least 4,268 unlawful requests and by as many as 10,101 unlawful requests. ID. C. This widespread pattern, as reflected within the population of unreturned ballots analyzed by Dr. Briggs, reveals the unavoidable reality that, in addition to the calculations herein, third parties voted an untold number of unlawfully acquired absentee or mail-in ballots, which would not be in the database of unreturned ballots analyzed here. COGCA. The 21st of February 522. These unlawfully voted ballots prohibited properly registered persons from voting and reveal a pattern of widespread fraud down ballot as well. D. Further, as calculated by Matt Brainerd, there exists clear evidence of 20,311 absentee or early voters in Georgia that voted while registered as having moved out of state. CID. Attachment to report. Specifically, these persons were showing on the National Change of Address Database (NCOA) as having moved, or as having filed subsequent voter registration in another state also as evidence that they moved and even potentially voted in another state. The 20,311 votes by persons documented as having moved exceeds the margin by which Donald Trump lost the election by 7,641 votes. 61. E. Applying pro rata the above calculations separately to Cobb County based in the number of unreturned ballots, a range of 1,255 and 1,687 ballots ordered by third parties in a range of 2,338 and 2,897. Lost mail ballots, plus 10,684 voters documented in the NCOA as having moved, for a combined minimum of 14,276 missing and unlawful ballots, and maximum of 15,250 missing and unlawful ballots, which exceeds the statewide presidential race total margin by a range of as few as 1,606 ballots and as many as 2,580 in the county of Cobb alone, impacting the Cobb County Republican Party. Cobb County Republicans. 123. As seen from the expert analysis of Eric Quinnell, mathematical anomalies further support these findings, when in various districts within Fulton County such as vote gains that exceed reasonable expectations when compared to 2016, and a failure of gains to be normally distributed but instead shifting substantially toward the tail of the distribution in what is known as a platykurtic distribution. Dr. Quinnell identifies numerous anomalies such as votes to Biden in excess of 2016 exceed the registrations that are in excess of 2016. Ultimately, he identifies the counties in order of their excess performance over what would have fit in a 62. Normal distribution of voting gains, revealing a list of the most anomalous counties down to the least. These various anomalies provide evidence of voting irregularities. CX.27, Declaration of Eric Quinnell, with attachments. 124. In sum, with the expert analysis of William M. Briggs, Ph.D. based on recorded calls and declarations, the extent of missing and unlawfully requested ballots creates substantial evidence that the mail ballot system has fundamentally failed to provide a fair voting mechanism. In short, tens of thousands of votes did not count, while the pattern of fraud makes clear that tens of thousands were improperly counted. This margin of victory in the election for Mr. Biden was only 12,670 and cannot withstand most of these criticisms individually and certainly not in aggregate. 125. Cobb County, based on lost votes, unlawfully requested votes and NCOA data on these facts alone would consume more than the entire margin of the statewide difference in the presidential race. These election results must be reversed. 126. Applying pro rata the above calculations separately to Cobb County based in the number of unreturned ballots, a range of 1,255 and 1,687 ballots 63. Ordered by third parties in a range of 2,338 and 2,897 lost mail ballots, plus 10,684 voters documented in the NCOA as having moved, for a combined minimum of 14,276 missing and unlawful ballots, and maximum of 15,250 missing and unlawful ballots, which exceeds the statewide presidential race total margin by a range of as few as 1,606 ballots and as many as 2,580 in the county of Cobb alone, impacting the Cobb County Republican Party. Cobb County Republicans. CX. 1. 127. Mr. Brainerd also found a pattern in Georgia of voters registered at totally fraudulent residence addresses, including shopping centers, mail drop stores and other non-residential facilities 34. 128. In sum, with the expert analysis of William M. Briggs, Ph.D. based on extensive investigation, recorded calls and declarations collected by Matt Brainerd, see attachments to X. 1. Briggs report the extent of missing and unlawfully requested ballots creates substantial evidence that the mail ballot system has fundamentally failed to provide a fair voting mechanism. In 34 Matt Brainerd, https://twitter.com/Matt Brainerd, status 1,331,324,173,910,761,476. https://twitter.com/Matt Brainerd, status 1,331,299,873,556,086,787. S equals 20, https://twitter.com/Matt Brainerd, status 1,331,299,873,556,086,787. S equals 20. 64. Short, tens of thousands of votes did not count, while the pattern of fraud and mathematical anomalies that are impossible absent malign human agency makes clear that tens of thousands were improperly counted. This margin of victory in the election for Mr. Biden was only 12,670 and cannot withstand most of these criticisms individually and certainly not in aggregate. 129. Cobb County, based on lost votes, unlawfully requested votes and NCOA data on these facts alone would consume more than the entire margin of the statewide difference in the presidential race. 130. Russell Ramsland confirms that data breaches in the Dominion software permitted rogue actors to penetrate and manipulate the software during the recent general election. He further concludes that at least 96,600 mail-in ballots were illegally counted as they were not cast by legal voters. 131. In sum, as set forth above, for a host of independent reasons, the Georgia certified election results concluding that Joe Biden received 12,670 more votes that President Donald Trump must be set aside. 65. Count I. Defendants violated the Elections Clause in 42 U.S.C. Section 1983. 132. Plaintiffs reallege all preceding paragraphs as if fully set forth herein. 133. The Electors Clause states that, Act state shall appoint, in such manner as the legislature thereof may direct, a number of electors, for president. Art. 2, Section 1, CL. 2 emphasis added. Likewise, the Elections Clause of the U.S. Constitution states that, times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. Art. I, Section 4, CL. 1 emphasis added. 134. The legislature is the representative body which casts the laws of the people. Smiley, 285 U.S. at 193. Regulations of congressional and presidential elections, thus, must be in accordance with the method which the state has prescribed for legislative enactments. ID. At 367, see also ARES. State Legislature v. ARES. INDUP. Redistricting Common, 135 S. Court. 2652, 2668. 2015. 66. 135. Defendants are not part of the General Assembly and cannot exercise legislative power. Rather, defendants' power is limited to taking care that the laws be faithfully executed. Pa. Const. Art. IV. Section 2. Because the United States Constitution reserves for the General Assembly the power to set the time, place, and manner of holding elections for the President and Congress, county boards of elections and state executive officers have no authority to unilaterally exercise that power, much less to hold them in ways that conflict with existing legislation. 136. Defendants are not the legislature, and their unilateral decision to create a cure procedure violates the electors and elections clauses of the United States Constitution. 137. The Secretary of State and the State Election Board are not the legislature, and their decision to permit early processing of absentee ballots in direct violation of the unambiguous requirements of OCGA. Section the 21st of February 386 A2 violates the electors and elections clauses of the United States Constitution. 67. 138. Many affiants testified to many legal infractions in the voting process, including specifically switching absentee ballots or mail-in ballots for Trump to Biden. Even a Democrat testified in his sworn affidavit that before he was forced to move back to where he could not see, he had in fact seen, I also saw absentee ballots for Trump inserted into Biden's stack and counted as Biden votes. This occurred a few times. CX 18, par 12. 139. Plaintiff's expert also finds that voters received tens of thousands of ballots that they never requested. CX 1, Dr. Briggs report. Specifically, Dr. Briggs found that in the state of Georgia, based on a statistically significant sample, the expected amount of persons that received an absentee ballot that they did not request ranges from 16,938 to 22,771. This range exceeds the margin of loss of President Trump by 12,670 votes by at least 4,268 unlawful requests and by as many as 10,101 unlawful requests. 140. This widespread pattern, as reflected within the population of unreturned ballots analyzed by Dr. Briggs, reveals the unavoidable reality that, in addition to the calculations herein, third parties voted an untold number of unlawfully acquired absentee or mail-in ballots, which would not 68 be in the database of unreturned ballots analyzed here. COGCA. The 21st of February 522. These unlawfully voted ballots prohibited properly registered persons from voting and reveal a pattern of widespread fraud. 141. Further, as shown by data collected by Matt Brainerd, there exists clear evidence of 20,311 absentee or early voters in Georgia that voted while registered as having moved out of state. Specifically, these persons were showing on the National Change of Address Database NCOA as having moved, or as having filed subsequent voter registration in another state also as evidence that they moved and even potentially voted in another state. The 20,311 votes by persons documented as having moved exceeds the margin by which Donald Trump lost the election by 7,641 votes. 142. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the injunctive relief requested herein is granted. Defendants have acted and, unless enjoined, will act under color of state law to violate the elections clauses of the Constitution. Accordingly, the results for President and Congress in the November 3, 2020 election must be set aside. The results are infected with constitutional violations. Count 2. 69. The Secretary of State in Georgia counties violated the 14th Amendment U.S. Const. Amend. 1442. U.S.C. Section 1983. Denial of equal protection. Invalid enactment of regulations affecting observation and monitoring of the election. 143. Plaintiffs refer to and incorporate by reference each of the prior paragraphs of this complaint as though the same were repeated at length herein. 144. The 14th Amendment of the United States Constitution provides, nor shall any state deprive any person of life, liberty, or property, without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. See also Bush v. Gore, 531 U.S. 98, 104 2000. Having once granted the right to vote on equal terms, the state may not, by later arbitrary and disparate treatment, value one person's vote over the value of another's. Harper v. Virginia Board of Elections, 383 U.S. 663, 665 1966. Once the franchise is granted to the electorate, lines may not be drawn which are inconsistent with the Equal Protection Clause of the 14th Amendment. 70. 145. The court has held that to ensure equal protection, a problem inheres in the absence of specific standards to ensure its equal application. The formulation of uniform rules to determine intent based on these recurring circumstances is practicable and, we conclude, necessary. Bush v. Gore, 531. U.S. 98, 106, 121 S. Court. 525, 530, 148 L. ed. 2D 388 2000. 146. The equal enforcement of election laws is necessary to preserve our most basic and fundamental rights. The requirement of equal protection is particularly stringently enforced as to laws that affect the exercise of fundamental rights, including the right to vote. 147. In statewide and federal elections conducted in the state of Georgia, including without limitation the November 3, 2020, general election, all candidates, political parties, and voters, including without limitation plaintiffs, have a vested interest in being present and having meaningful access to observe and monitor the electoral process in each county to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. 71. 148. Moreover, through its provisions involving watchers and representatives, the Georgia Election Code ensures that all candidates and political parties in each county, including the Trump campaign, have meaningful access to observe and monitor the electoral process to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. C. E.g. In plain terms, the statute clearly prohibits opening absentee ballots prior to Election Day, while the rule authorizes doing so 3 weeks before Election Day. There is no reconciling this conflict. The State Election Board has authority under OCGA. Section the 31st of February 21 to adopt lawful and legal rules and regulations, but no authority to promulgate a regulation that is directly contrary to an unambiguous statute. Rule the 14th of January 183-0.9-.15 is therefore plainly and indisputably unlawful. 72. Plaintiffs also bring this action under Georgia law, OCGA. Section the 21st of February 522, grounds for contest. 149. A result of a primary or election may be contested on one or more of the following grounds. 150. 1. Misconduct, fraud, or irregularity by any primary or election official or officials sufficient to change or place in doubt the result. 2. When the defendant is ineligible for the nomination or office in dispute. 3. When illegal votes have been received or legal votes rejected at the polls sufficient to change or place in doubt the result. 4. For any error in counting the votes or declaring the result of the primary or election, if such error would change the result. Or 5. For any other cause which shows that another was the person legally nominated, elected, or eligible to compete in a runoff primary or election. OCGA. Section the 21st of February 522. 151. Several affiants testified to the improper procedures with absentee ballots processing, with the lack of auditable procedures with the logs in the computer systems, which violates Georgia law and federal election law. C-73. Also, 50 U.S.C. Section 20701 requires the retention and preservation of records and papers by officers of elections under penalty of fine and imprisonment. 152. The State Election Board re-adopted Rule the 14th of January 183-0.9-.15 on November 23, 2020 for the upcoming January 2021 runoff election. 153. A large number of ballots were identical and likely fraudulent. An affiant explains that she observed a batch of utterly pristine ballots, 14. Most of the ballots had already been handled, they had been written on by people, and the edges were worn. They showed obvious use. However, one batch stood out. It was pristine. There was a difference in the texture of the paper, it was if they were intended for absentee use but had not been used for that purposes. There was a difference in the feel. 15. These different ballots included a slight depressed pre-fold so they could be easily folded and unfolded for use in the scanning machines. There were no markings on the ballots to show where they had come tilde from, or where they had been processed. These stood out. 16. In my 20 years of experience of handling ballots, I observed that the markings for the candidates on these ballots were unusually uniform, perhaps even with a ballot marking device. By my estimate in observing these ballots, approximately 98% constituted votes for Joe Biden. I only observed 2 of these ballots as votes for President Donald J. Trump. CX. 15. 154. The same affiant further testified specifically to the breach of the chain of custody of the voting machines the night before the election, stating, 74. We typically receive the machines, the ballot marking devices, on the Friday before the election, with a chain of custody letter to be signed on Sunday, indicating that we had received the machines and the counts on the machines when received, and that the machines have been sealed. In this case, we were asked to sign the chain of custody letter on Sunday, even though the machines were not delivered until 2 a.m. in the morning on Election Day. The Milton precinct received its machines at 1 a.m. in the morning on Election Day. This is unacceptable and voting machines should not be out of custody prior to an election day. ID. 155. Defendants have a duty to treat the voting citizens in each county in the same manner as the citizens in other counties in Georgia. 156. As set forth in count I above, defendants failed to comply with the requirements of the Georgia Election Code and thereby diluted the lawful ballots of the plaintiffs and of other Georgia voters and electors in violation of the United States Constitution guarantee of equal protection. 157. Specifically, defendants denied the plaintiffs equal protection of the law and their equal rights to meaningful access to observe and monitor the electoral process enjoyed by citizens in other Georgia counties by mandating that representatives at the pre-canvass and canvass of all absentee and mail ballots be either Georgia barred 75. Attorneys are qualified registered electors of the county in which they sought to observe and monitor. B. Not allowing watchers and representatives to visibly see and review all envelopes containing official absentee and mail-in ballots either at or before they were opened and or when such ballots were counted and recorded, and C. Allowing the use of Dominion Democracy Suite software and devices, which failed to meet the Dominion Certification Report's conditions for certification. 158. Instead, defendants refused to credential all of the Trump Republicans submitted watchers and representatives and or kept Trump campaign's watchers and representatives by security and metal barricades from the areas where the inspection, opening, and counting of absentee and mail-in ballots were taking place. Consequently, defendants created a system whereby it was physically impossible for the candidates and political parties to view the ballots and verify that illegally cast ballots were not opened and counted. 159. Many affiants testified to switching absentee ballots or mail-in ballots for Trump to Biden, including a Democrat. He testified in his sworn affidavit that before he was forced to move back to where he could not see, he 76. Had in fact seen absentee ballots for Trump inserted into Biden's stack and counted as Biden votes. This occurred a few times. CX. 18, par. 12. 160. Other Georgia County Boards of Elections provided watchers and representatives of candidates and political parties, including without limitation watchers and representatives of the Republicans and the Trump campaign, with appropriate access to view the absentee and mail-in ballots being pre-canvassed and canvassed by those county election boards and without restricting representatives by any county residency or Georgia bar licensure requirements. 161. Defendants intentionally and/or arbitrarily and capriciously denied plaintiffs access to and/or obstructed actual observation and monitoring of the absentee and mail-in ballots being pre-canvassed and canvassed by defendants, depriving them of the equal protection of those state laws enjoyed by citizens in other counties. 162. Defendants have acted and will continue to act under color of state law to violate plaintiffs' right to be present and have actual observation and access to the electoral process as secured by the Equal Protection Clause of the United States Constitution. 77. 163. Defendants further violated Georgia voters' rights to equal protection insofar as defendants allowed the Georgia counties to process and count ballots in a manner that allowed ineligible ballots to be counted, and through the use of Dominion Democracy Suite, allowed eligible ballots for Trump and McCormick to be switched to Biden or lost altogether. Defendants thus failed to conduct the general election in a uniform manner as required by the Equal Protection Clause of the 14th Amendment in the Georgia Election Code. 164. Plaintiffs seek declaratory and injunctive relief holding that the election, under these circumstances, was improperly certified and that the governor be enjoined from transmitting Georgia's certified presidential election results to the Electoral College. Georgia law forbids certifying a tally that includes any ballots that were not legally cast, or that were switched from Trump to Biden, through the unlawful use of Dominion Democracy Suite software and devices. 165. Alternatively, plaintiffs seek declaratory and injunctive relief holding that the election, under these circumstances, was improperly certified and that the governor be required to recertify the results declaring that Donald 78. Trump has won the election and transmitting Georgia's certified presidential election result in favor of President Trump. 166. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the declaratory and injunctive relief requested herein is granted. Indeed, the setting aside of an election in which the people have chosen their representative is a drastic remedy that should not be undertaken lightly, but instead should be reserved for cases in which a person challenging an election has clearly established a violation of election procedures and has demonstrated that the violation has placed the result of the election in doubt. Georgia law allows elections to be contested through litigation, both as a check on the integrity of the election process and as a means of ensuring the fundamental right of citizens to vote and to have their votes counted accurately. OCGA. Section the 21st of February 520 et seq. 167. In addition to the alternative requests for relief in the preceding paragraphs, hereby restated, plaintiffs seek a permanent injunction requiring the county election boards to invalidate ballots cast by 1. Voters whose signatures on their registrations have not been matched with ballot, envelope and voter registration check, 2. All dead votes, and 4. All 900. Military ballots in Fulton County that supposedly were 100% for Joe Biden. 79. Count 3. 14th Amendment Equal Protection Clause U.S. Const. Amend. 1442 U.S.C. Section 1983. Denial of due process. Disparate treatment of absentee mail-in voters among different counties. 168. Plaintiffs incorporate each of the prior allegations in this complaint. Voting is a fundamental right protected by the 14th Amendment to the United States Constitution. The 14th Amendment protects the right to vote from conduct by state officials which seriously undermines the fundamental fairness of the electoral process. Marks v. Stinson, 19 F3D 873. 889 3 DCIR. 1994 Griffin, 570 F2D at 1077-78. H. Having once granted the right to vote on equal terms, the state may not, by later arbitrary and disparate treatment, value one person's vote over that of another. Bush, 531. U.S. at 10405. 169. Defendants are not part of the General Assembly and cannot exercise legislative power. Rather, defendants' power is limited to executing the laws as passed by the legislature. Although the Georgia General Assembly may enact laws governing the conduct of elections, no legislative enactment may contravene the requirements of the Georgia or United States constitutions. Schenke, 257 A2D at 898. 170. Federal courts possess broad discretion to fashion an equitable remedy. Black Warrior Riverkeeper, Inc. v. U.S. Army Corps of Engineers, 781 F3D 1271, 1290, 11 CIR. 2015 Castle v. Sangamo Weston, Inc. 837. F. 2D 1550, 1563, 11 CIR. 1988 The decision whether to grant equitable relief, and, if granted, what form it shall take, lies in the discretion of the district court. 171. Moreover, the extent that a voter is at risk for having his or her ballot rejected due to minor errors made in contravention of those requirements, the decision to provide a notice and opportunity to cure procedure to alleviate that risk is one best suited for the legislature. Particularly in light of the open policy questions attendant to that decision, including what the precise contours of the procedure would be, how the concomitant burdens would be addressed, and how the procedure would impact the confidentiality and counting of ballots, all of which are best left to the legislative branch of Georgia's government. ID. 81. 172. The disparate treatment of Georgia voters, in subjecting one class of voters to greater burdens or scrutiny than another, violates equal protection guarantees because the right of suffrage can be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise. Reynolds, 377 U.S. at 555. Rice v. McAllister, 268 or 125, 128, 519 P2D 1263, 1265 1975 Heitman v. Brown GRP, Inc., 638 SW2D 316, 319, 1982 Mo. App, Lexus 3159, at asterisk Fort Mo. Court, App, 1982 Prince v. Bear River Mutt, Inns, Co., 2002 UT 68, 41, 56 P3D 524, 536-37 Utah 2002. 173. Defendants are not the legislature, and their unilateral decision to create and implement a cure procedure for some but not all absentee and mail-in voters in this state violates the Due Process Clause of the United States Constitution. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the injunctive relief requested herein is granted. 82. Count IV. 14th Amendment, U.S. Const. Art. I Section 4, CL. 1, Art. 2, Section 1, CL. 2, Amend. 14, 42 U.S.C. Section 1983. Denial of due process on the right to vote. 174. Plaintiffs refer to and incorporate by reference each of the prior paragraphs of this complaint as though the same were repeated at length herein. 175. The right of qualified citizens to vote in a state election involving federal candidates is recognized as a fundamental right under the 14th Amendment of the United States Constitution. Harper, 383 U.S. at see also Reynolds, 377 U.S. at 554. The 14th Amendment protects the right of all qualified citizens to vote, in state as well as in federal elections. Indeed, ever since the Slaughterhouse Cases, 83 U.S. 36, 1873, the United States Supreme Court has held that the Privileges or Immunities Clause of the 14th Amendment protects certain rights of federal citizenship from state interference, including the right of citizens to directly elect members of Congress. C. Twining v. New Jersey, 211 U.S. 78, 97, 1908, citing Ex parte Yarborough, 110 U.S. 651, 663-64, 1884. See also Oregon v. Mitchell, 400. U.S. 112, 148-49, 1970 Douglas, J., concurring collecting cases. 83. 176. The fundamental right to vote protected by the 14th Amendment is cherished in our nation because it is preservative of other basic civil and political rights. Reynolds, 377 U.S. at 562. Voters have a right to cast a ballot in an election free from the taint of intimidation and fraud, Burson v. Freeman, 504 U.S. 191, 211, 1992, and C. Confidence in the integrity of our electoral processes is essential to the functioning of our participatory democracy. Purcell v. Gonzalez, 549 U.S. 1, 4, 2006 per curiam. 177. Obviously included within the right to vote secured by the Constitution is the right of qualified voters within a state to cast their ballots and have them counted, if they are validly cast. United States v. Classic, 313. U.S. 299, 315. U.S. 299, 315, 1941. U.S. 299, 315, 1941. T. Right to have the vote counted, means counted. At full value without dilution or discount. Reynolds, 377 U.S. at 555, N.29. Quoting South v. Peters, 339 U.S. 276, 279, 1950 Douglas, J., dissenting. 178. Every voter in a federal election, whether he votes for a candidate with little chance of winning or for one with little chance of losing, has a right under the Constitution to have his vote fairly counted, without its being distorted by fraudulently cast votes. Anderson v. United States, 417 U.S. 211, 227, 1974. See also Baker v. Carr, 369 U.S. 186, 208, 1962. Invalid or 84. Fraudulent votes, debase and dilute the weight of each validly cast vote. C. Anderson, 417 U.S. at 227. 179. The right to an honest count is a right possessed by each voting elector, and to the extent that the importance of his vote is nullified, wholly or in part, he has been injured in the free exercise of a right or privilege secured to him by the laws and Constitution of the United States. Anderson. 417 U.S. at 226 quoting Pritchard v. United States, 181 F2D 326, 331 6 CIR F due to absence of quorum, 339 U.S. 974 1950. 180. Practices that promote the casting of illegal or unreliable ballots or fail to contain basic minimum guarantees against such conduct can violate the 14th Amendment by leading to the dilution of validly cast ballots. C. Reynolds, 377 U.S. at 555 T. Right of suffrage can be denied by a debasement or dilution of the weight of a citizen's vote just as effectively as by wholly prohibiting the free exercise of the franchise. 181. In Georgia, the signature verification requirement is a dead letter. The signature rejection rate for the most recent election announced by the Secretary of State was 0.15%. The signature rejection rate for absentee ballot applications was 0.00167%, only 30 statewide. Hancock County, Georgia, 85. Population 8,348, rejected 9 absentee ballot applications for signature mismatch. Fulton County rejected 8. No other metropolitan county in Georgia rejected even a single absentee ballot application for signature mismatch. The state of Colorado, which has run voting by mail for a number of years, has a signature rejection rate of between 0.52% and 0.66%. 35. The state of Oregon had a rejection rate of 0.86% in 2016. 36. The state of Washington has a rejection rate of between 1% and 2%. 37 if Georgia rejected absentee ballots at a rate of 0.52% instead of the actual 0.15%, approximately 4,600 more absentee ballots would have been rejected. Count V. There was widespread ballot fraud. OCGA the 21st of February 522. 182. Plaintiffs refer to and incorporate by reference each of the prior paragraphs of this complaint as though the same were repeated at length herein. 35 https://duckduckgo.com/ Q equals Colorado plus signature plus rejection plus rate and T equals OSX and E equals web last visited November 25th, 2020. 36 https://www.vox.com/2140131/Oregon vote by mail 2020 presidential election last visited November 25th, 2020. 37 https://www.salon.com/2020/09/08/more than 55000 mail ballots rejected so far. Here's how to make sure your vote gets counted last visited November 25th, 2020. 86. 183. Plaintiffs contest the results of Georgia's election, with standing conferred under pursuant to OGCA. The 21st of February 521. 184. Therefore, pursuant to OGCA. The 21st of February 522, for misconduct, fraud, or irregularity by any primary or election official or officials sufficient to change or place in doubt the result. The foundational principle that Georgia law nonetheless allows elections to be contested through litigation, both as a check on the integrity of the election process and as a means of ensuring the fundamental right of citizens to vote and to have their votes counted accurately. Martin B. Fulton County BD, of Registration and Elections, 307 GA. 193, 194, 835 SE2D 245, 248 2019. The Georgia Supreme Court has made clear that plaintiffs need not show how the voters would have voted if their absentee ballots had been regular, only had to show that there were enough irregular ballots to place in doubt the result. COCGA section the 21st of February 520 at Seek, Meade v. Sheffield, 278 GA. 268, 272, 601 SE2D 99, 102 1994. The Supreme Court invalidated an election and ordered a new election because it found that thus, it was not incumbent upon the plaintiff to show how the 481 voters would have voted if their absentee ballots had been regular. He only had to show that there were enough irregular ballots to place in doubt the result. He succeeded in that task. 87. ID. At 271 citing Howell v. Fears, 275 GA. 627, 571 SE2D 392, 2002 primary results invalid where ballot in one precinct omitted names of both qualified candidates. 185. The glitches in the Dominion system that seem to have the uniform effect of hurting Trump and helping Biden have been widely reported in the press and confirmed by the analysis of independent experts. 186. Prima facie evidence in multiple affidavits shows specific fraudulent acts, which directly resulted in the flipping of the race at issue, of votes being switched in Biden's favor away from Trump during the recount. B. The lack of procedures in place to follow the election code, and the purchase and use Dominion voting system despite evidence of serious vulnerabilities. C. A demonstration that misrepresentations were made about a pipe burst that sent everyone home, while first 6, then 3, unknown individuals were left alone until the morning hours working on the machines. 88. D. Further, a failure to demonstrate compliance with the Georgia's election codes, in maintaining logs on the voting system for a genuine and sound audit, other than voluntary editable logs that prevent genuine audits. While the bedrock of this democratic republic rests on citizens' confidence in the validity of our elections and a transparent process, Georgia's November 3, 2020 general election remains under a pall of corruption and irregularity that reflects a pattern of the absence of mistake. At best, the evidence so far shows ignorance of the truth. At worst, it proves a knowing intent to defraud. 187. Plaintiff's expert also finds that voters received tens of thousands of ballots that they never requested. CX. 1. Dr. Briggs report. Specifically, Dr. Briggs found that in the state of Georgia, based on a statistically significant sample, the expected amount of persons that received an absentee ballot that they did not request ranges from 16,938 to 22,771. This range exceeds the margin of loss of President Trump by 12,670 votes by at least 4,268 unlawful requests and by as many as 10,101 unlawful requests. 89. 188. This widespread pattern, as reflected within the population of unreturned ballots analyzed by Dr. Briggs, reveals the unavoidable reality that, in addition to the calculations herein, third parties voted an untold number of unlawfully acquired absentee or mail-in ballots, which would not be in the database of unreturned ballots analyzed here. COGCA. The 21st of February 522. These unlawfully voted ballots prohibited properly registered persons from voting and reveal a pattern of widespread fraud. 189. Further, there exists clear evidence of 20,311 absentee or early voters in Georgia that voted while registered as having moved out of state. Specifically, these persons were showing on the National Change of Address Database NCOA as having moved, or as having filed subsequent voter registration in another state also as evidence that they moved and even potentially voted in another state. The 20,311 votes by persons documented as having moved exceeds the margin by which Donald Trump lost the election by 7,641 votes. 190. Plaintiffs, expert Russell Ramsland concludes that at least 96,600 mail-in ballots were fraudulently cast. He further concludes that up to 136,098 ballots were illegally counted as a result of improper manipulation of the Dominion software. Ramsland F. 191. The very existence of absentee mail-in ballots created a heightened opportunity for fraud. The population of unreturned ballots analyzed by William Briggs, Ph.D., reveals the probability that a far greater number of mail ballots were requested by third parties or sent erroneously to persons and voted fraudulently, undetected by a failed system of signature verification. The recipients may have voted in the name of another person, may have not had the legal right to vote and voted anyway, or may have not received the ballot at the proper address and then found that they were unable to vote at the polls, except provisionally, due to a ballot outstanding in their name. 192. When we consider the harm of these uncounted votes, and ballots not ordered by the voters themselves, and the potential that many of these unordered ballots may in fact have been improperly voted and also prevented proper voting at the polls, the mail ballot system has clearly failed in the state of Georgia and did so on a large scale and widespread basis. The size of the voting failures, whether accidental or intentional, are multiples larger than the margin of votes between the presidential candidates in the 91 state. For these reasons, Georgia cannot reasonably rely on the results of the mail vote. 193. The right to vote includes not just the right to cast a ballot, but also the right to have it fairly counted if it is legally cast. The right to vote is infringed if a vote is cancelled or diluted by a fraudulent or illegal vote, including without limitation when a single person votes multiple times. The Supreme Court of the United States has made this clear in case after case. See, e.g., Gray v. Sanders, 372 U.S. 368, 380 1963. Every vote must be protected from the diluting effect of illegal ballots. Crawford v. Marion CNTY. Election BD, 553 U.S. 181, 196 2008. Plurality op. Of Stevens, J. There is no question about the legitimacy or importance of the state's interest in counting only the votes of eligible voters. Accord Reynolds v. Sims, 377 U.S. 533, 554 to 55 and N.29 1964. 194. Plaintiffs have no adequate remedy at law. As seen from the expert analysis of William Higgs, Ph.D., based on actual voter data, tens of thousands of votes did not count, and tens of thousands of votes were unlawfully requested. 92. 195. The 14th Amendment Due Process Clause protects the right to vote from conduct by state officials which seriously undermines the fundamental fairness of the electoral process. Marks v. Stinson, 19F3D 873. 889 3D-CIR. 1994 Griffin v. Burns, 570 F2D 1065, 1077-78 1st CIR. 1978. 196. Separate from the Equal Protection Clause, the 14th Amendment's Due Process Clause protects the fundamental right to vote against the disenfranchisement of a state electorate. Duncan v. Poitras. 657 F2D 691, 702 5th CIR. 1981. When an election process reaches the point of patent and fundamental unfairness, there is a due process violation. Florida State Conference of NAACP. V. Browning, 522 F3D 1153, 1183-84, 11 CIR. 2008 quoting Roe v. Alabama, 43 F3D 574, 580. 11 CIR 1995 citing Curry v. Baker, 802 F2D 1302, 1315, 11 CIR 1986. See also Griffin, 570 F2D at 1077. If the election process itself reaches the point of patent and fundamental unfairness, a violation of the Due Process Clause may be indicated in relief under Section 1983. Therefore, in order. Marks. V. Stinson, 19 F3D 873, 889 3D-CIR. 1994 enjoining winning state Senate candidate from exercising official authority where absentee ballots were obtained and cast illegally. 93. 197. Part of court's justification for such a ruling is the Supreme Court's recognition that the right to vote into free and fair elections is one that is preservative of other basic civil and political rights. See Black, 209 F sub, 2D. At 900 quoting Reynolds, 377 U.S. at 561 to 62. Since the right to exercise the franchise in a free and unimpaired manner is preservative of other basic civil and political rights, any alleged infringement of the right of citizens to vote must be carefully and meticulously scrutinized. See also Yekwo v. Hopkins, 118 U.S. 356, 370 1886. The political franchise of voting is regarded as a fundamental political right because it's preservative of all rights. 198. T. Right to vote, the right to have one's vote counted, and the right to have one's vote given equal weight are basic and fundamental constitutional rights incorporated in the Due Process Clause of the 14th Amendment to the Constitution of the United States. Black, 209 F sub, 2D. At 900, a state law that allows local election officials to impose different voting schemes upon some portions of the electorate and not others violates due process. Just as the Equal Protection Clause of the 14th Amendment prohibits state officials from improperly diluting the right to vote, the Due Process Clause of the 14th Amendment forbids state 94 officials from unlawfully eliminating that fundamental right. Duncan, 657. F. 2D at 704. Having once granted the right to vote on equal terms, defendants may not, by later arbitrary and disparate treatment, value one person's vote over that of another. Bush, 531 U.S. at 10405. 199. In statewide and federal elections conducted in the state of Georgia, including without limitation the November 3, 2020 general election, all candidates, political parties, and voters, including without limitation plaintiffs, have a vested interest in being present and having meaningful access to observe and monitor the electoral process to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. 200. Moreover, through its provisions involving watchers and representatives, the Georgia Election Code ensures that all candidates and political parties, including without limitation plaintiff, Republicans, and the Trump campaign, shall be present and have meaningful access to observe and monitor the electoral process to ensure that it is properly administered in every election district and otherwise free, fair, and transparent. 95. 201. Defendants have a duty to guard against deprivation of the right to vote through the dilution of validly cast ballots by ballot fraud or election tampering. Rather than heeding these mandates and duties, defendants arbitrarily and capriciously denied the Trump campaign and Republicans meaningful access to observe and monitor the electoral process by mandating that representatives at the pre-canvass and canvass of all absentee and mail ballots be either Georgia barred attorneys or qualified registered electors of the county in which they sought to observe and monitor, and b. not allowing watchers and representatives to visibly see and review all envelopes containing official absentee and mail-in ballots either at the time or before they were opened and or when such ballots were counted and recorded. Instead, defendants refused to credential all of the Trump campaign submitted watchers and representatives and or kept Trump campaign's watchers and representatives by security and metal barricades from the areas where the inspection, opening, and counting of absentee and mail-in ballots were taking place. The lack of meaningful access with actual access to see the ballots invited further fraud and cast doubt of the validity of the proceedings. 96. 202. Consequently, defendants created a system whereby it was physically impossible for the candidates and political parties to view the ballots and verify that illegally cast ballots were not opened and counted. 203. Defendants intentionally and or arbitrarily and capriciously denied plaintiffs access to and or obstructed actual observation and monitoring of the absentee and mail-in ballots being pre-canvassed and canvassed by defendants, and included the unlawfully not counting and including uncounted mail ballots, and that they failed to follow absentee ballot requirements when thousands of voters received ballots that they never requested. Defendants have acted and will continue to act under color of state law to violate the right to vote and due process as secured by the 14th Amendment to the United States Constitution. 204. Plaintiffs have no adequate remedy at law and will suffer serious and irreparable harm unless the injunctive relief requested herein is granted. 205. When we consider the harm of these uncounted votes and ballots not ordered by the voters themselves and the potential that many of these 97 unordered ballots may in fact have been improperly voted and also prevented proper voting at the polls, the mail ballot system has clearly failed in the state of Georgia and did so on a large scale and widespread basis. The size of the voting failures, whether accidental or intentional, are multiples larger than the margin in the state. For these reasons, Georgia cannot reasonably rely on the results of the mail vote. 206. Relief sought is the elimination of the mail ballots from counting in the 2020 election. Alternatively, the presidential electors for the state of Georgia should be disqualified from counting toward the 2020 election. 207. The United States Code 3 U.S.C. 5 provides that if any state shall have provided, by laws enacted prior to the day fixed for the appointment of the electors, for its final determination of any controversy or contest concerning the appointment of all or any of the electors of such state, by judicial or other methods or procedures, and such determination shall have been made at least 6 days before the time fixed for the meeting of the electors, such determination made pursuant to such law so existing on said day, and made at least 6 days prior to said time of meeting of the electors, shall be conclusive, and shall govern in the counting of the electoral votes as provided in the Constitution, and is hereinafter regulated, so far as the ascertainment of the electors appointed by such state is concerned. 3 U.S.C.S. Section 5. 98. Request for relief. 208. Accordingly, plaintiffs seek an emergency order instructing defendants to decertify the results of the general election for the office of President. 209. In the alternative, plaintiffs seek an emergency order prohibiting defendants from including in any certified results from the general election the tabulation of absentee and mailing ballots which do not comply with the election code, including, without limitation, the tabulation of absentee and mail-in ballots. Trump campaign's watchers were prevented from observing or based in the tabulation of invalidly cast absentee and mail-in ballots which lack a secrecy envelope, or contain on that envelope any text, mark, or symbol which reveals the elector's identity, political affiliation, or candidate preference, do not include on the outside envelope a completed declaration that is dated and signed by the elector, or are delivered in person by third parties for non-disabled voters. 210. When we consider the harm of these uncounted votes, and ballots not ordered by the voters themselves, and the potential that many of these unordered ballots may in fact have been improperly voted and also prevented 99. Proper voting at the polls, the mail ballot system has clearly failed in the state of Georgia and did so on a large scale and widespread basis. The size of the voting failures, whether accidental or intentional, are multiples larger than the margin in the state. For these reasons, Georgia cannot reasonably rely on the results of the mail vote. Relief sought is the elimination of the mail ballots from counting in the 2020 election. Alternatively, the electors for the state of Georgia should be disqualified from counting toward the 2020 election. Alternatively, the electors of the state of Georgia should be directed to vote for President Donald Trump. 211. For these reasons, plaintiff asks this court to enter a judgment in their favor and provide the following emergency relief. 1. An order directing Governor Kemp, Secretary Raffensperger, and the Georgia State Board of Elections to decertify the election results. 2. An order enjoining Governor Kemp from transmitting the currently certified election results to the Electoral College. 3. An order requiring Governor Kemp to transmit certified election results that state that President Donald Trump is the winner of the election. 100. 4. An immediate order to impound all the voting machines and software in Georgia for expert inspection by the plaintiffs. 5. An order that no votes received or tabulated by machines that were not certified as required by federal and state law be counted. 6. A declaratory judgment declaring that Georgia Secretary of State Rule the 14th of January 183-0.9-.15 violates the Electors and Elections Clause, U.S. Const. Art. I. Section 4. 7. A declaratory judgment declaring that Georgia's failed system of signature verification violates the Electors and Elections Clause by working a de facto abolition of the signature verification requirement. 8. A declaratory judgment declaring that current certified election results violates the Due Process Clause, U.S. Const. Amend. 14. 9. A declaratory judgment declaring that mail-in and absentee ballot fraud must be remedied with a full manual recount or statistically valid sampling that properly verifies the signatures on absentee ballot envelopes and that invalidates the certified results if the recount or sampling analysis shows a sufficient number of ineligible absentee ballots were counted. 101. 10. An emergency declaratory judgment that voting machines be seized and impounded immediately for a forensic audit by plaintiffs expects. 11. A declaratory judgment declaring absentee ballot fraud occurred in violation of constitutional rights, election laws, and under state law. 12. A permanent injunction prohibiting the Governor and Secretary of State from transmitting the currently certified results to the Electoral College based on the overwhelming evidence of election tampering. 13. Immediate production of 36 hours of security camera recording of all rooms used in the voting process at State Farm Arena in Fulton County, GA from 12 a.m. to 3 a.m. until 6 p.m. on November 3rd. 14. Plaintiffs further request the court grant such other relief as is just and proper, including but not limited to the costs of this action and their reasonable attorney fees and expenses pursuant to 42 U.S.C. 1988. Respectfully submitted, this 25th day of November, 2020. 102. Caldwell, Probst & Deloach, LLP. S. Harry W. McDougald. Harry W. McDougald. Georgia bar number, 463,076. Caldwell, Probst & Deloach, LLP. 2 Ravinia Drive, Suite 1600. Atlanta, Georgia 30346. 404-843-1956 telephone. 404-843-2737 facsimile. McDougald at cpdlawyers.com. Counsel for plaintiffs. S. Sydney Powell asterisk. Sydney Powell PC. Texas bar number, 16,209,700. Julia Z. Holler asterisk. Emily P. Newman asterisk. Virginia bar license number, 84,265. 2911 Turtle Creek Boulevard, Suite 300. Dallas, Texas 75219. Asterisk application for admission pro hack vice. Forthcoming. L. Lynn Wood. GA bar number, 774,588. L. Lynn Wood, PC. P.O. Box 52,584. Atlanta, GA 303050584. Telephone, 404-891-1402. Howard Kleinhandler asterisk. New York Bar No. 2,657,120 Howard Kleinhandler Esquire 369 Lexington Avenue, 12th floor. New York, New York 10017. Office 917-793-1188. Mobile 347-840-2188. Howard at kleinhandler.com. www.kleinhandler.com. 103. Asterisk application for admission pro hack vice forthcoming. Attorneys for plaintiffs. 104. Document outline. Nature of the action. The parties. Jurisdiction and venue. Statement of facts. I defendants' unauthorized actions violated the Georgia Election Code and caused the processing of defective absentee ballots. B. Unlawful early processing of absentee ballots. C. Unlawful audit procedures. 2. Evidence of fraud. A pattern showing the absence of mistake. B. The voting machines, secrecy. Software used by voting machines throughout Georgia is crucial. I. As part of the scheme and artifice to defraud the plaintiffs, the candidates and the voters of undiminished and unaltered voting results in a free and legal election, the defendants and other persons known and unknown committed the following violation. Additional specific fraud. Multiple expert reports and statistical analyses prove hundreds of thousands of votes were lost or shifted that cost President Trump and the Republican candidates of Congressional Districts 6 and 7 their races. Count I. Defendants violated the Elections Clause in 42 U.S.C. Section 1983. Count 2. The Secretary of State in Georgia counties violated the 14th Amendment U.S. Const. Amend. 42 U.S.C. Section 1983. Denial of equal protection. Invalid enactment of regulations affecting observation and monitoring of the election. Count 3. 14th Amendment Equal Protection Clause U.S. Const. Amend. 42 U.S.C. Section 1983. Denial of due process. Disparate treatment of absentee mail-in voters among different counties. Count IV. 14th Amendment U.S. Const. Art. I Section 4 CL 1 Art 2 Section 1 CL 2 Amend. 42 U.S.C. Section 1983. Denial of due process on the right to vote. Count V. There was widespread ballot fraud. OCGA the 21st of February 522. Request for relief. Tweet what you have read.
Sorry about the long gap at the end of that. Probably not watching anymore at this point. But, there it is.